ಯಾಕೆ ಫುಲ್ ಡೇ ಅಲ್ಲ ಇವತ್ತು? ಯಾಕೆ ಮಂಡೆಗೆ ಏನು ಅರ್ಜೆನ್ಸಿ ಏನಿದೆ?
Lord, we had been filing these memos for posting.
Ah.
Interim, they have filed the charge sheet now.
ಗಿವ್ ಇಟ್. ಅದು FR ಇದ್ರೆ ಕಂಪ್ಲೈ ಮಾಡ್ಬೇಕು.
That I'll, in fact, one I have filed for withdrawal.
All right, give all the memos, we'll see. Fresh matters ಎಲ್ಲ ಕೊಡಿ.
Fresh matter.
Anything specific, mention at 2:30. Or we'll vacate the stay, next date. Yes. Any mentioning, we'll hear at 2:30. Monday vacating stay, I can't post, madam. We'll give the memo. You give the memo. ಏನಾಗಿದೆ? What happened? That I know, sir. Why passport? Where do you want to go? Give it, yes. ಅದು Wednesday ಹಾಕಿ ಮೇಡಮ್, ಅದು pregnant.
My lord,
Monday ಆಗಲ್ಲ, ಕೊಡಿ ಮೆಮೊ ಕೊಡಿ. Monday not possible.
My
Sir,
lord.
Monday already 300 are listed, I'm not possible.
my lord, serial number
Order from the court. Principal of the college.
Charge sheet ಆಗಿದೆಯಾ? I will not put the clock back now. Yes.
serial number 104, my lord.
You want to withdraw?
I'm going to withdraw the petition.
ತಗೊಂಬಿಡಿ.
So please.
Hey, whatever has happened, fresh matter ಕೊಡಿ. Yes.
Sir.
Give it, give it. ಅದು ಇಸ್ಕೊಳ್ಳಿ. ಇಸ್ಕೊಳ್ಳಿ. All right. 6ನೇ ತಾರೀಕು, 4ನೇ ತಾರೀಕಿಗೆ ತಗೊಳ್ಳಿ. ಆಯ್ತು. ಅದು GM ಗೆ ಹೋಗ್ಬೇಕು, ಪಕ್ಕದ ಕೋರ್ಟ್. ರೌಡಿ ಶೀಟ್ ಅಂದ್ರೆ GM. You should go to the next court, sir. FIR ಆಗಿದೆ ಕೊಡಿ. Yes. Fresh matter. Pending. Give it. Yes. We'll see. Give it. Yes. Give it. Yes. Huh. 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 We'll see. Which year? 20? All right, give it, we'll see. We'll fix it next week, but other next week ಹಾಕ್ತೇನೆ. ಅಲ್ಲ, other next week ಹಾಕ್ತೇನೆ. Week commencing after the 9th. Yes. All right. I guess the learned Solicitor General is the learned Solicitor General is for this case? Yes, sir.
Yes, subject to your lordship's convenience.
Yeah, no, we'll start. Yes. With this in the first list,
Yes,
we'll
sir.
start this. Yes.
I'm grateful, my lord. I'm appearing in person before your lordship for the first time. It's really a privilege, my lord. I was looking forward to.
Yes.
Lord, I'll be very brief because your lordships are aware of
Yes, sir.
broad conspectus of the facts.
Yes.
But from the petitioner's perspective, your lordships have also dealt with, my lord, the issues as, my lord, judgments, my lord, which I'm going to refer.
Yes.
So I'll not read, I'll just say the propositions which your lordships have already read.
Yes.
Lord, my submissions are going to be, my lord, in 5 compartments. First, the
Settle. Yes. Settle down, sir. Yes.
yes, yeah, please.
Yes, sir.
From the order, which is page 40 vacant.
Which the impugned order?
Yeah.
I don't know, sir, you are appealing for petitioner. Oh,
Page 41 starts. Kindly come to page 42.
Yes.
It reads like this. Petition from Sri T.J. Abraham seeking grant of sanction for prosecution Sri Siddaramaiah, Honorable Chief Minister Karnataka, for commission of offences under section 7 so and so
or the Prevention of Corruption Act. Kindly mark the next phrase. Sections 59, 61, 62, etc., of Bharatiya Nyaya Samhita. The said petition seeks sanction, etc. Now, after this, there is no reference to any provision of either the Indian Penal Code or the BNS Act. And sanction is given to prosecute under these provisions. Now, as this honorable court is very much aware, these provisions came into force on 1st of July. The last of the alleged acts against the petitioner's family, not against the petitioner's family, ended on 5/1/2022 when the allotment of sites was made. Admittedly, on that date
BNS was not there.
was not there. How can there be a prosecution of under a law which are kindly permit
No,
me
you're-
to show
Talking of post facto law.
Article 20 may kindly.
Yes, yes.
I agree, it cannot, it has to be prospect. I have an answer to that. Though
So,
Dr.
Post-
Singhvi
post
didn't
facto law,
argue,
That is,
Yes,
That
so
is-
Article 20 it died.
that's all.
Now, this has two limbs. Number one, it is hit by Article 20.
All right.
Number two, His Excellency, the Governor does not even whisper about this aspect of the matter. He could have applied his mind and said, this is relatable to provisions under the IPC Act. These are the provisions, etc. He could have said it, all right, notwithstanding the prayer. But that is not the case here. Since there is no mention of any one of these provisions in the entire body of the order of the Governor. So on that count alone, this order has to go, is my very respectful. And the
Here the others.
second aspect is that ultimately all the allegations are against Parvati and her brother. Not a single allegation against the petitioner. As having passed an order, having taken a decision,
That's
made a recommendation.
elaborately submitted.
That is,
Yes.
no, the point I'm submitting is there vicarious liability of a husband for the deeds of either the brother-in-law or the wife? That's a short question.
No, that stage of drawing in vicarious liability on investigation or on
No,
something
no,
else has
government
not
will
yet
be
arrived.
satisfied
We'll
that
Not the
husband is
way-
liable for all the acts of his wife
see.
or her brother.
We'll
If
see.
he is satisfied, yes, sanction can be given.
Lord, the scheme of the architecture of. the
Pious,
prevent-
pious obligation is well understood. But there is no such,
Obligations, highest obligations are well understood.
Pious
Not-
obligations, yes. Yes, sir.
but husband's obligation for the crimes of a lady.
That will, we'll hear this also.
So one of the pious obligation on the lighter side
Yes,
is not to shift a criminal liability on the wife.
to take on himself.
Yeah, yes, that is one of the pious, that is on the lighter side.
Yes, yes.
Yes. Lord, my submissions are, my lord, in six compartments.
Yes, sir.
Lord, first, Lord, the arguments are advanced about the scope of the governor's power under section 17A,
Yes.
relying upon the parameters prescribed under section 19.
Yes, sir.
Lord, I would wish to assist your lordships on the question that section 17A stage
Yes.
and application of mind. Well, I'll take your lordships through, my lord. I'm just giving
Yes.
outline of what I'm respectfully assisting your lordship with.
Yes.
What are the differences between the provisions of 17A and 19, and resultantly, what will be the parameters of governor's jurisdiction, governor's power, or governor's duty, whatever we may call it, while exercising powers under 17A or 19. Second, my respectful submission is that the parameters of the governor's jurisdiction under 17A would be akin to what is described by the Honorable Supreme Court in Lalita Kumari's case, that he has to see a prima facie case whether the facts emerges a cognizable offense or not. If the facts reflects commission of a cognizable offense, he is not a judge. He is not supposed to sit in appeal and decide whether offense is committed, not committed. He has to say that, yes, as alleged, there is a cognizable offense, and he has to discharge his function under 17A. Third, the decision of the governor, because of two reasons, by the virtue of the office he holds, and he deals with my lord, other constitutional functionaries generally, and considering the very nature and scope of section 17A, is such that his reasons, which are recorded in the order of approving 17A investigation, need not be elaborate. It must reflect application of mind nonetheless, because any elaborate reasonings will have a tendency of prejudicing the potential accused during the investigation as well as during the trial. But I must show, it's the duty of my lord the governor to show that there is an application of mind, and thereafter the reasons are recorded and the reasons can be found from the file also. The next submission, my lord, which I am making, my lord, my learned friend's argument was that in case of one complainant, the governor issued notice. In two cases, the honorable governor did not issue notice. My lord, my respectful submission in law, and which I will substantiate by, my lord, the provisions as well as the legal interpretations given by the courts,
Yes.
that at the stage of 17A, there is no requirement of any principles of natural justice.
Yes.
He may have chosen to issue notice in one case, but non-issuance of notice, even in that one case, would not have created any prejudice to anyone, because in law, there is no contemplation of hearing. And I will elaborate, my lord,
At the
to-
stage of 17.
at the stage of 17A, because Supreme Court has went to the extent of saying, even at the stage of 19, hearing is not required.
Yes.
Yes, because 19 is post-investigation.
Yes.
Lord, next contention I would, my lord, assist your lordship with is why the governor was required to act in his own discretion and not, my lord, as per the aid and advice, as, my lord, contended by the petitioner. Aid and advice of the Council of Ministers under Article 163 of the Constitution will have no application when the Honorable Chief Minister is facing an allegation. I'm saying only allegation.
Yes.
It is yet to be decided. And the governor is called upon to decide 17A. My lord, the submission, my lord, which my learned senior, my lord, just now made,
Yes.
Professor Ravi Kumar Verma, my lord, a very eminent counsel, my lord. I have an occasion to oppose him in one of the reservation matters before the Constitution bench. My lord, the submission is that mention of BNS vitiates the decision of the governor. My lord, that submission is required to be, my lord, only pointed out to be rejected for the simple reason that suppose IPC offenses are also mentioned. The governor will not go under 17A which offenses are made out. Governor will only say that yes, prima facie, criminal offenses are made out, and it will be for the investigating officer to decide under what provisions charge sheet, if any, is to be filed. Because the investigation may result into filing of the charge sheet, it might result into filing of a closure report, but in the event of filing of a charge sheet, the investigating officer will take his own independent decision based on the material of the record that these are the provisions which are attracted, which, Lord, in a given case
Little
of
earlier also procedure, it is not yet referred even for investigation. So while referring, these crimes may be noted, may not be noted.
correct, my lord.
That's all.
And even if it is noted, IO will not be bound by them. Maybe the governor has missed 2-3 sections, hypothetically. The IO can still say that the honorable governor did not have full facts. The honorable governor was relying upon only a written complaint. Now I have investigated, I have documentary evidence, I have oral evidence, I have other evidence, and now I feel that 3 other sections are also required to be added. Then he would add it. So mention of BNS, IPC, or any of the sections or non-mention thereof would not vitiate the order. In any case, will not cause any prejudice to the petitioner so as to give him an opportunity to challenge it on that ground. And last, my lord, which again, my lord, my learned senior friend, my lord, mentioned that the criminal liability of the husband, of the wife, cannot be attributed to the husband. Dr. Singhvi also made a submission that I have not made any recommendation. If that is so, then fine, then 17A is not required. The complainant can straight away proceed with the criminal complaints. Then 17A goes, my lord, their problem is solved. They should withdraw the petition that I have not done anything in my official capacity. I have not recommended anything. I am not involved. Maybe my wife was beneficiary. All right, then 17A is not required. Then what are we arguing for? Why are we troubling your lordship with by showing justification for validity of 17A order? Look, it's a self-defeating suicidal argument, in my respectful submission. Now, my lords, my lord, I have prepared a summary of my submissions, my lord.
Yes, sir.
And so far as governor's application of mind is concerned, my lord, I have gone through the file. I will share the file with your lordships,
Yes.
and without making it a precedent, I
Yes.
will share with the other side also.
Yes.
Though, my lord, in law, my submission
Okay.
is that the potential accused cannot have an access to
Yes.
that file, but we don't wish, my lord, anything to play hide and seek. My lord, I'll show it to the petitioner also that this is the application of mine, and based upon the considerations which are reflected from the file, the governor has reached the conclusion that this is a case for 17A, and he has passed the order. My lord, these are my written submissions. I'll give it.
Yes, sir.
Lord, page 5, your lordship may directly come to page 5. Up to 4, my lord, I have only pointed out. This is the skeleton on
Right.
which, my lord, I'll address your lordships.
Yes.
Lord, 26th of July 24, a show cause notice dated 26th July 24, which is placed by, my lord, the petitioner at annexure C, was issued to the petitioner in relation to the petition seeking grant of approval for investigation on the basis of complaint filed by respondent number 3. Lord, it is an admitted position that what is the content of the show cause notice is only the complaint of respondent number 3 and not the other 2 complaints. Because my submission is going to be even this step was not necessary. Therefore, non-compliance with other 2 makes no difference, creates no prejudice, gives no cause of action. Then, my lord, on 31st of July 24, a cabinet note was put up for consideration of the Council of Ministers in relation to the show cause notice issued by the Honorable Governor of Karnataka to the Honorable Chief Minister to respond within 7 days as to why sanction for prosecution should not be granted, as requested by one Sri T.J. Abraham in his application dated 26 July 24. The cabinet note in its introductory paragraph notes as under. Lord, please read. The Chief Minister, with his note dated 27th July 24, the next day of, my lord, receipt of notice, has directed the Chief Secretary to place the matter of a show cause notice issued by the Honorable Governor of Karnataka, addressed to the Chief Minister of Karnataka, video number so-and-so, before the cabinet, along with all the materials available on record with the Urban Development Department and after consulting with the learned Advocate General. Accordingly, the Chief Secretary, after obtaining the Advocate General, it should be the opinion of the Advocate General, but the mistake is in the original note, my lord, it's not in this.
Yes.
Accordingly, Chief Secretary, after obtaining the opinion of the learned Advocate General and examining the records, directed the Urban Development Department to put up a cabinet note with details along with the opinion of the Advocate General on the matter for consideration of the cabinet. My lord, here, on a lighter note, my lord, nowhere the government writes learned Advocate General. My lord, that is the practice throughout. I'm not criticizing. I'm saying on a lighter note, because, my lord, there was, my lord, an eminent lawyer called F.E. Smith. He had said 3 things. That in the court of law, never believe 3 things. When the honorable judge says, my learned brother, he neither means that he is learned, nor he treats him as a brother. Second, when I say my learned friend, we are generally friends, but we rarely treat each other as learned. And my lord, or a and when we say that with profound respect, but with profound respect generally mean, as per him, my lord, this is not my interpretation, that your lordships have not understood, but let me make your lordship understand. And my lord, he has elaborately detailed that my lord, with respect means you have not understood. Lord, with profound respect means you have completely not understood.
Not at all understood.
Not at all understood. So these are the jargons. So we call each other learned. And that is the irony. My lord, when your lordship set aside the order of the trial court, your lordship would say the learned judge has not understood even basic fundamentals of law. My lord, if the second part is true, then how is he a learned judge? But this is, my lord, what we live with, my lord, since centuries. Then the cabinet note dated 31st of July at annexure D from page 267 of the writ petition filed by the petitioner. Then Council of Minister through its cabinet decision advised the Honorable Governor to withdraw the notice dated so-and-so issued by him to the Honorable Chief Minister based on the petition and addendum dated so-and-so filed by one T.J. Abraham and to proceed forthwith to reject the said application by denying prior approval and sanction as requested by the petitioner Abraham. The decision of the cabinet is, my lord, also placed by them.
Yes.
The petitioner submitted his reply to the show cause notice dated 26 July 24, which is also annexed, and something very interesting from the note prepared by the Chief Secretary. Thereafter, the learned Advocate General. Thereafter, the matter comes to the cabinet. Thereafter, the Honorable Chief Minister prepares his reply, etc., which I'll come, my lord, when I deal with that. Respondent number 2 placed the file in relation to the issue at hand, along with the decision of the cabinet dated so-and-so and reply of the petitioner dated so-and-so before the Honorable Governor. The respondent number 2 is the Secretary to the Honorable Governor, Lord, whom I represent, and he placed that these are the papers. This is the note of cabinet. The cabinet has to say this, and all documents, as I will show from the file, complaints, documentary evidence is annexed with the complaint, etc., my lord. The opinion of the learned Advocate General, everything was placed. Then, 8/8/24, the Honorable Governor directed respondent number 2 to put up the file along with comparative statements of the petitioners. Petition, my lord, he understands, my lord, to be complaints.
Oh, this was done.
Yes, my lord. Well, there is an elaborate application of mine. I'll show from the file. I'll share it with my learned friend. The Honorable Governor directed respondent number 2, that is his principal
Yes.
secretary, to put up the file along with comparative statements of the petitions received in relation to the grant of sanction, reply of the Chief Minister, and the decision of the cabinet. That you give me in this format, then I'll make up my mind. Then 14th August, comparative statements as referred above were placed before the Honorable Governor for his perusal. 14th August 24, after perusing the file and discussing the issues, the Honorable Governor directed to resubmit the file along with notes or analysis points as dictated. The learned Governor dictates that this is the allegation of the complainant. This is what the cabinet note says. This is what the reply of the Honorable Chief Minister says. And this is the note. The note is dictated by him. I'll place it. It's a big chart, my lord. Several charts were prepared, and the Honorable Governor, my lord, himself dictates. Based on, and this comes, my lord, in the noting file also. It's not that I'm saying for the first time that it was dictated by the Governor. In the noting file, my lord, it comes that it was dictated by the Governor. Based on the comparative statement and available documents and petitions. The file, along with all the above referred documents and comparative statements as dictated by the Honorable Governor, was placed before the Honorable Governor for necessary orders. The order of approval for investigation was passed by the Honorable Governor, and my lord, thereafter, my lord, the petitioner is before your lordships. Now, my lord, taking the first point first. Lord, your lordships are aware, prior to, my lord, the enactment of the new Prevention of Corruption Act,
Yes.
the amendment to the Prevention of Corruption Act, my lord, which was in 2000 and
26/7, 2008.
yes, my lord, 18, there was no concept of an approval prior to
Yes,
the investigation. The only concept was pre-cognizance sanction
sanction.
under section 19. My lord, for the first time, 17A comes, my lord, your lordships have read and reread this provision, but only read kindly, my lord, on my request,
Yes.
page 8, page 8, only subsection 1.
Yes, sir.
No police officer shall conduct any inquiry or investigation into any offense alleged to have been committed by a public servant under this act. It doesn't talk of BNS or IPC. Under this act, where the alleged offense is relatable to any recommendation made or decision taken by such public servant in discharge of his official functions or duties without the previous sanction of ABCD. Well, according to me, this case would fall within B and C, but I'll have to independently substantiate that it is the governor in case of the Honorable Chief Minister who is not supposed to act as per the aid and advice of the Council of Ministers. Now, my lord, so far as this is concerned, my lord, I have already pointed out that the scope is very, very limited. I have to, as a governor, see whether the complaint and the documents which are placed makes out a cognizable offense which requires investigation. It may result in a charge sheet or the report under 173 as we call it, or a closure report as per old section 169. But that's not the call the governor is permitted also to take. The governor cannot say that I have examined and cognizable offense is made out. It's of a serious nature. It will be attracting this provision. It will be attracting so much punishment, etc., etc. No, he will go by prima facie case that whether it needs to be examined by an investigating agency as an investigation under the provisions of law. Lord, your lordships have had an occasion to consider, my lord, this honorable court had considered, your lordships, my lord, thereafter, my lord, gave a detailed
Yes.
and illuminating decision. But Sri Rupa,
Yes.
my lord, I would your lordships like me to, my lord, place for your lordship
Yes.
consideration?
Two very different concepts.
Yes, my lord.
Approval and sanction, they stand on
They
different.
stand on different footing. The parameters are different, the considerations are different, the way in which you deal with the application is also different.
In that case, there was nothing said,
Yes.
nothing said except saying we grant approval.
Approval.
There was no application of mind at all in that case.
Yes.
That's why that was.
And my lord, they are relying upon these judgments to show that there has to be an application of mind. My lord, in my respectful submission, to canvass a proposition that any administrative order has to be after application of mind, you don't need any judgment.
It's rudimentary.
It's elementary, my lord. It has to be after application of mind. You don't need any judgment. There are certain, my lord, universal propositions which doesn't need to be supported by any judgment. I'm straightway conceding it has to be after application of mind. It will depend upon facts of each case and what is the extent of application of mind
That
is
Case to
relevant.
case basis.
Is based on facts to facts.
Facts.
So, my lord, I'm placing it, my lord, but I'm not reading, my lord, this judgment. Lord, kindly see what would be the scope of the power, my lord, because your lordships would be laying down the law in while deciding this. Not only with reference to a scenario where the Honorable Governor, who is a constitutional functionary, is deciding the approval issue of the Honorable Chief Minister, who is also a constitutional functionary. 17A applies across board.
Yes.
In case of a tehsildar or a patwari, maybe the tehsildar is or deputy collector is this authority under 17A.
17A.
So what is the scope of his inquiry? What is the scope of his application of mind? Whether to exercise 17A power as requested by the complainant or not to exercise. Lord, that broadly, in my respectful submission, we can get assistance, my lord, from Lalita Kumari judges. That your lordship would find at page 12. My lord, I can take your tell your lordship, my lord, whatever paragraphs I have quoted,
It's quoted.
I have, my lord, the full text of the judgment, which
Yes.
I'll place.
Yes,
But this is only for ready reference.
yes,
I'll place, my lord, the entire bunch, my lord, for your lordship's consideration.
yes,
Right now, my lord, I'm not giving,
yes.
my lord, please come, my lord. This is a your lordships are aware, it's a constitution
Yes,
bench. 5 honorable judges, my lord. 31.
yes,
And I'll skip some of the paras, my lord. The FIR is a pertinent document in the criminal law procedure of our country, and its main object from the point of view of the informant is to set the criminal law in motion, and from the point of view of the investigating authorities is to obtain information about the alleged criminal activity so as to be able to take suitable steps to trace and to bring to book the guilty. Now kindly come to page 30, para 49. I'll skipping, my lord, other paragraphs.
yes,
49, highlighted bold part. Consequently, the condition that is sine qua non for recording an FIR under section 154 of the code is that there must be information, and that information must disclose a cognizable offense. This applies squarely to 17A. If any information disclosing a cognizable offense is led before an officer in charge of the police station, someone has forgotten, my lord.
these things happen.
Yeah, these are, my lord, some interesting incidents in the virtual hearing.
They are the-
Must disclose a cognizable offense. If any information disclosing a cognizable offense is led before an officer in charge of the police station satisfying the requirement of section 154(1), the said police officer has no other option except to enter the substance thereof in the prescribed format, that is to say, to register a case on the basis of such information. Lord, I'm not comparing the police officer with the governor, but I'm saying police officers' function under 154 is the function of any approving authority under section 17A. He may be a tehsildar or he may be the honorable governor. That whether prima facie offense is made out, then not only is duty bound, it is not only his right, he is duty bound to accord approval. The provision of 154 of the code is mandatory, and the officer concerned is duty bound to register the case on the basis of information disclosing a cognizable offense. Thus, the plain words of section 154(1) of the code have to be given their literal meaning. The use of the word shall in 154 of the code clearly shows the legislative intent that it is mandatory to register an FIR if the information given to the police discloses the commission of a cognizable offense. Therefore, the context in which the word shall appears in section 154(1), the object for which it has been used, and the consequences that will follow from the infringement of direction to register FIRs, all these factors clearly show that the word shall used in 154(1) needs to be given its ordinary meaning, etc. My lords. My lord, my learned friend may be tempted to say that in case of 17A, it is not shall. The shall is used only with regard to the police officer and not the governor.
Yes,
I am using this judgment, my lord, for assisting your lordships to say that these are the parameters the governor will bear in mind. That I am not supposed to conduct a trial. I am not supposed to even examine whether I would ultimately give sanction for section 19,
no, it is at stage of 17.
17.
So it's one.
Because section 19, he would be having the material filed by the police, and his parameters would be again different. The threshold would be high.
This is only prima facie.
This is only prima facie. If there is a cognizable offense made out, he has to give approval, whether he's governor or a tehsildar. Yes. The only exception, my lord, in Lalita Kumari is that in case of Prevention of Corruption Act or matrimonial offenses, conduct a kind of a preliminary inquiry. That is for the police officer. Here, he has to apply his mind. Preliminary inquiry does not mean
6 clauses in para 20.1, 120.1.
120.1.
Yes.
So here, my lord, he is conducting a preliminary inquiry within his mind that it is whether case is made out or not. My lord, why I say this, my lord, what will be the disastrous consequence if we read, my lord, the principles of natural justice into it? As I said, my lord, it's not a case of honorable governor and the honorable chief minister. This would apply to all public servants under the Prevention of Corruption Act. In many cases,
So if I can, so the suggestion is, if natural justice is to prevail prior to 17A, and you're you're paraphrasing 17A to 154, then before registration of FIR, notice will have to be given heard.
exactly,
That will
my
have-
learned friend in
it would
fact
be there.
cited, my learned friend in fact
That is what you're
cited
trying to,
Rajesh
yes.
Agarwal judgment,
yes. that's right.
where he said that he had an honor to assist the Honorable Court. I incidentally also had an honor to assist the Honorable Court, where my learned friend either inadvertently missed that part where the Honorable Court said that in criminal matters, hearing is not required in that very judgment.
So-
Otherwise, my lord, kindly see the
Otherwise,
consequence.
prior to 154(1), every accused will have to be heard. Now, of course, in the new BNS under 218, and it's pre-cognizant stage, yes, a notice is required.
No, even there, the Supreme Court says not required.
Yes.
As far as my learned friend was on VC, it missed out. I said the argument was that to declare account fraud is like an FIR. So how can you hear before an FIR? The court made the distinction that no hearing is required before FIR. But to declare an account fraud, which is akin to criminal, you must have a hearing. That is the distinction I made.
That's
Perhaps you
correct.
missed it
Yes.
on the VC.
Lord,
Yes,
kindly,
yes.
kindly, my lord, consider if my learned friend is right that before granting approval under 17A, a hearing is required. 17A is for the prevention of corruption offences. It applies over the board
Yes,
to every public servant.
yes.
The moment, my lord, notice is given, there are all possibilities, my lord, that the evidence will be lost. That is one more reason, my lord, not to read hearing or principles of natural justice under 17A. Suppose, my lord, a collector were to give approval for the deputy collector's corruption case, and he is in office, he might, my lord, tamper with the evidence. He might misplace the file. The evidence will go. This is one more reason why 154 or 17A, no hearing.
Except the preliminary inquiry that is in 120.1 of Lalita. Kumari.
Yes, my lord, in a given case, in Lalita Kumari says, my lord, that if it is something, lord, suppose I go and file a FIR which is completely absurd, that Mr. So-and-so I approached and he demanded 50,000 rupees. Then straightway don't register an FIR and pick him up, conduct a kind of a preliminary inquiry because it's the station house officer who does this.
Yes,
While here in 17A, why that preliminary inquiry is also not contemplated. Only contemplation is whether you find cognizable offense being made out from the material on record. So merely because the Honorable Governor thought it fit to issue notice in one case does not necessarily mean that non-issuance of notice in other two
will
cases
initiate the procedure.
would vitiate the order. Now, my lord, I am relying upon at page 14, my lord's, my lord, very illuminating judgment, my lord, in Dr. Ashok versus the state, where your lordships were pleased to
Yes,
lord, distinguish.
17,
And I think this is the first judgment, my lord,
yes,
juxtaposing 17A and 19, my lord.
yes,
And Lord, your lordships were based upon that judgment, my lord. There is a direction also issued, my lord, by the
High Court.
High Court, my lord,
Yes.
that even it applies to the magistrates. The magistrate also cannot straightway issue process or call upon the complainant to be in the witness box, etc. The complainant will have to go with 17A. So, my lord, I'm not reading, my lord,
Yes,
Dr.
yes.
Ashok, my lord, it is your lordship's judgment,
Yes.
my lord. Now I will show, my lord, how there is an application of mine.
Huh.
My lord, kindly have, my lord, the original file. I'll share it with my learned friend, Mr. Singhvi and Professor Ravi Kumar also, but I'll have one more copy. You have copies? And the learned advocate general also, my lord, by virtue of his office, though he
Good
is
evening.
not concerned with the
Good, good
lists between, my lord, the honorable governor and honorable chief minister, but I understand his position, my lord. And by virtue of his office, he is entitled to have the access. Huh? He is rightly sitting on our side, my lord. My lord, government is always on the left. Some, my lord, honorable in High Court, honorable judge asked me, in Gujarat also, my lord, the government sits on the left. that
Yes,
why does the government sits on the left? I said, we always sit on the right side of law.
yes, sir.
I'll share the
This-
original
this is
file.
the
which
entire
are-
file?
This is original.
Yes.
Lord, I have shared the original file with your lordships.
Yes, sir.
And obviously, my lord, I am getting, giving Xerox to my learned friends. And I can assure your lordships,
I'll hold this with me.
certainly, my lord, your lordships can,
Yes.
only, my lord, ensure that it doesn't go
No, no,
out.
That's,
And I would request my learned friends also that can remain only with them and their clients. It may not travel beyond. Nothing is secret, confidential, or anything which needs to be hidden, but there is some sanctity attached to the governor's
Office, to the
office. my
office.
lord. And I'm, my lord, at the cost of repetition, maintaining that this is without making it a precedent.
yes,
Just to show that there is nothing to hide, A, and two, there is always, there is an application of mind, according to me, more than what was required. My lord, your lordships are not supposed to go through the entire bulk. Please see, my lord, the first part, which is, my lord, the noting section.
noting section.
This is the noting section. You have that? Give it to the learned AG. Yes. My lord, this is the note, page 1. Your lordship would find it is continuously paginated
Yes,
and paragraphed through till the decision is taken.
yes,
My lord, this is the note placed by the, my lord, principal secretary to the governor for consideration of the governor. I'll not read it, my lord. It merely reproduces para 1. Kindly peruse the petition submitted by Sri T.J. Abraham, dated so-and-so, placed in the file. Then, my lord, what is the content he mentions? And eventually, my lord, he writes, please peruse papers. He requests the honorable governor. The complaint and addendum submitted by Sri T.J. Abraham may be perused in file. He has requested sanction of prosecution against the sitting chief minister under various provisions quoted so-and-so. With this fact, the file is submitted for further orders. Now, my lord, the honorable governor on page 3 and note number 8 makes this note. I have heard Sri T.J. Abraham in person and gone through the petition and supporting documents submitted by him. Prima facie, I am of the view that there might be irregularities and misuse of power. He doesn't reach a conclusion of criminal offense, but he took care to see that there is genuinely a person. It's not an anonymous kind of a, or a pseudonymous kind of a complaint.
because the complainant himself has appeared.
It has appeared,
Yeah.
he was heard, he shown the documents, etc. Hence, issue show cause notice to Sri so-and-so, calling explanation within 7 days. Thereafter, my lord, kindly come to page 5. Lord, it further goes on. As per the order of the honorable governor, draft copy of the later, my lord, that is draft copy of the show cause notice, my lord. Then
Yes.
the show cause notice goes. Please
Yes,
come to page 7. Lord, again, the special secretary to the governor writes, kindly peruse the letter dated 3rd August 24 received from Sri so-and-so and letter dated so-and-so received from the chief secretary to government placed in the file. The chief secretary has submitted the cabinet decision dated so-and-so along with the enclosures. The cabinet note is of 91 pages, but possibly the longest cabinet note in the history of this country after or even pre-independence. And something more interesting, I'll, my lord, show to your lordships. Pages along with relevant copies of the judgments and legal opinion in reply to the show cause notice dated so-and-so issued by the Honorable Chief Minister. Further, so-and-so has submitted his reply to the show cause notice dated so-and-so along with legal opinion and relevant records, which runs through 60 plus odd pages. The state cabinet, for the facts and reasons mentioned in the cabinet decision, has strongly advised the Honorable Governor, not just an advice, it's a strong advice to the governor to withdraw the notice dated so-and-so issued to the Honorable Chief Minister based on the petition and addendum dated so-and-so filed by one T.J. Abraham and to proceed forthwith to reject the said application by denying prior approval. The Honorable Chief Minister in his reply has requested to peruse his reply as well as the advice rendered by the cabinet with its resolution dated so-and-so and to withdraw the notice issued to him and to deny prior approval and sanction sought by the petitioner by rejecting his application. With the above details and along with records submitted, the file is placed before the honorable for kind perusal and orders. My lord, these are the documents submitted by Mr. Abraham as well as by the government. Then, my lord, at the foot is the note by the note by the honorable governor, put up along with comparative statements of petitions, chief minister's reply, and the cabinet decision. Put it in 3 different compartments, which your lordship would find. Your lordship need not read it, just, my lord, for the flavor of it. My lord, page 1236. No, I'm sorry, my lord, it is 1224, my lord. There are 3 or 4, my lord, A3 type chart prepared. Just, my lord, have by way of an example, 1224. Well, there is a chart, my lord, of this size. It would be
Oh,
easier
yes,
to
yes,
find, my lord.
Yes, yes.
1224.
Yes.
There are 3 columns. Petition of Sri T.J. Abraham,
Yes.
then specific rebuttal of allegations in the application for approval or sanction, and
Yes.
factual metrics.
Yes.
Lord, similarly, if your lordship goes through the other chart, and I'll come, my lord, show cabinet reply and CM's reply,
Yes.
which is, my lord, the second chart at page 1208. Then comparative statement of all the 3 petitions.
Yes.
This is where the governor comes to know that they are relating to the same transaction.
Yes.
So I need not follow even an empty formality of issuing notices. The allegations are same with respect to the same land, etc. Now kindly come back, my lord, with me to the my lord, noting section. Your lordships may kindly come to page 8 now of the file noting section.
Yes. Yes.
21, my lord, para number 21. The file notings are I seriatim numbered and paginated. As directed at para 20, comparative statement of petition received from so-and-so, and the Honorable Chief Minister reply and the cabinet decision are placed in the file for kind perusal of the Honorable Court. Now, please see 22 is very, very important, my lords. This is the Honorable Governor's noting. Peruse the file, discuss the issues. He discusses the issues with the officials, my lord, who are assisting him. Hence, resubmit the file along with notes, analysis points as dictated. My lord, he goes through these charts and dictates at page 1236 his own prima facie conclusions. My lord, page 1236, allegation, reply, and the 3rd column is what is dictated by the Honorable Governor. It is from page 1236 to 1225. So the page numbering is reversed, my lord, as your lordship, sir.
Yeah, that is the government files.
Government files. So, my lord, each and every allegation, the reply of the Honorable Chief Minister and cabinet, he considers and he dictates that this appears to be the prima facie situation. Then, my lord, para 9, page 9. This is, my lord, by the special secretary to the governor. Pre-paras may kindly be perused. The petition received from, then 3 numbers, requesting grant of sanction for prosecution in respect of irregularities conducted and corrupt practice adopted by so-and-so.
Yes.
This is the language used in the complaint. He doesn't say that this is, we are dealing with sanction for prosecution. He is reproducing the language of the complainants.
Yes.
Then 26, as directed, the file along with the above details, documents, and comparative statements, please note, dictated notes by the Honorable. That is Honorable Governor. That, my lord, appears to be the way in which, my lord, the Honorable Governor is referred to within the office.
Yes.
Is placed before the Honorable for further necessary orders. Then, my lord, page 11. Petitions received from Sri T.J. Abraham. My lord, this is the note, my lord, prepared by the Honorable Governor. It is signed, my lord, at page 25
Yes.
by the Honorable Governor.
Yes.
Petitions received from Sri so-and-so so-and-so and petition with additional documentation, petition from so-and-so, 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 requesting grant of sanction for prosecution in respect of irregularities conducted and corrupt practices adopted by so-and-so, concerning allotment of alternative site by MUDA under various sections of PC Act and BNSS Act has been perused. He reproduces what the complainant say. He doesn't say, I am dealing with sanction prosecution. In view of the allegations and on a prima facie perusal of the petitions for grant of sanction for prosecution and materials in support of the allegations, a show cause notice dated so-and-so along with the copy of the petition by Sri T.J. Abraham and material in support of the allegations was issued to Sri so-and-so. The reply to the show cause notice dated so-and-so along with annexures was received at Office of His Excellency the Governor of Karnataka on so-and-so. It appears from the material annexed to the reply, my lord. I need not read, my lord. It reproduces, my lord, the contents of various things, my lord.
Yes.
Please come to page 15
Yes.
or, my lord, at page 16,
That is 31.2.
31.2. The Chief Minister is the head of Council of Ministers. The Council of Ministers is normally required to act fairly and in a bona fide manner. However, the Council of Ministers is appointed on the recommendation of the Chief Minister. So please note here, this is the constitutional mandate under Article 164. 164 requires that the governor would appoint ministers on the recommendation of the Honorable Chief Minister. This is one of the factors which the governor considers whether to act on his own discretion or as per the aid and advice. It is but natural that stance of Council of Ministers is in support of the Chief Minister. Hence, in such extraordinary circumstances, it is hard to ascertain that the Council of Ministers have acted fairly and in a bona fide manner. The governor, under Article 163 of the Constitution, is required to act under the said aid and advice of Council of Ministers. However, an exception may arise when consideration is being done for grant of sanction for prosecution of the Chief Minister and the decision of Council of Ministers is affected by apparent bias. As regards the application of doctrine of aid and advice is concerned, this has been conclusively settled in state of Maharashtra versus so-and-so that sanction to prosecute the Chief Minister is the exclusive function of the governor to be exercised by him in his discretion, followed by the decision in case of Dr. J. Jayalalitha versus so-and-so, wherein it was further amplified that it is erroneous to say that the view of the Supreme Court was based on a concession made by counsel, and the perusal of the relevant part of the judgment shows that the court has expressed its opinion that such concession was rightly made. In the present matter, the allegations and the material in support of allegations would prima facie indicate that the said land was given to SC person by due course of law. The record of the said land was transferred from the father to children and again from children to father. This mystery was not considered by the state cabinet. When the notification, now he says why I'm not relying upon state cabinet. First he says that even as per law, I'm supposed to use my own discretion, not aid and advice. Now he goes further. State cabinet, when the notification for land acquisition issued and the denotification order was issued, she so-and-so was the member of Legislative Assembly from so-and-so constituency, as well as a member of Mysore Urban Development Authority. And further, this land was purchased by a brother-in-law of so-and-so, wherein the seller was from the constituency of so-and-so, and later on after getting the land converted into the residential purpose, gifted it to the wife of so-and-so, who became the owner of the property, and the application for allocation of alternative sites came to be moved on the basis of relinquishment of agricultural land. On the basis of this application, MUDA passed the resolution pursuant to the amendment to allot alternate sites. It has been specifically averred that the rules was specifically amended, averred in the complaint. He is giving a prima facie consideration whether a cognizable offense is made out, which needs investigation. A rule was specifically amended from 40-60 to 50-50 to aid this transaction where so-and-so was the chief minister. Further, the petition seeking grant of sanction for prosecution and material provided clearly indicate that Sri so-and-so, son of Sri so-and-so, participated in MUDA meeting, which resulted in allotment of alternative site in very prime layout called Vijayanagar. These facts were placed before the Council of Ministers. The aforesaid brief facts, when correlated with the material in support of grant of sanction, clearly establish that there is apparent bias in the decision taken by the Council of Ministers in favor of Sri so-and-so. Due to this apparent bias, the present matter requires my independent application of mind to the petition seeking grant of sanction for prosecution and the material in support of the same. It is seen from the decision taken by the Council of Ministers that a committee under the chairmanship of Sri so-and-so was constituted to look into the present matter. However, the government, upon considering the facts of the present matter, as reported in the media and newspapers, appointed a high-level single-member inquiry committee under the Commission of Inquiries Act. It appears from the terms of reference of the high-level single-member committee that there are serious allegations involving illegal allotment of alternative sites, illegal allotment of land, and irregularities in allocation of land. Further, the constituting a committee under an IAS officer and immediately constituting one-member committee under a retired judge of the High Court and the government's own acceptance that there is potential big-ticket scam in allotment of sites by MUDA does not inspire much confidence. It is well settled legal principle that the persons against whom allegations are made should not be empowered to decide the course of action. Even after such grave allegations being involved in the present matter and the fact that materials prima facie supports the allegations, therefore the decision taken by the Council of Ministers is irrational. Well, this is what MP judgment says, that if it is found that it is irrational or vitiated, biased, or other considerations I'll come to, my lord, then the governor will have to act at his discretion. As even after the appointment of high-level single-member inquiry committee on such serious allegation, the Council of Ministers do not consider the entire material in support of the allegation. The subject of binding of the advice of the Council of Ministers for Governor and discretionary power of Governor during special circumstances is well discussed and decided in case of Madhya Pradesh Police Establishment versus so-and-so. The 5 judges bench of the Supreme Court has held that if on these facts and circumstances, the governor cannot act in his own discretion, there would be a complete breakdown of rule of law in as much as it would then be open for governments to refuse sanction in spite of overwhelming material showing that a prima facie case is made out. If in cases where prima facie is clearly made out, sanction to prosecute high functionaries is refused or withheld, democracy itself will be at stake. This is one quotation from the Supreme Court judgment. It would then lead to a situation where people in power may break the law with impunity, safe in the knowledge that they will not be prosecuted, as requisite sanction will not be granted. On the point raised by the Council of Ministers that an application for previous approval under Section 17A can be made only by police officer and not by a private person. My lord, something which was unfortunately argued by the petitioner, despite, and I will come to that, a very fair and correct legal opinion given by the learned Advocate General saying that no, this is not true. It is not. Any private individual is also, as held by your lordships, bound to approach.
It is only investigation and inquiry should not commence by a police officer without approval.
Exactly, my lord. I am
It is
great.
not that he should seek approval. There is no law that he only should seek approval.
Yes, my lord. But that was
Approval can be sought definitely that's what I have also held. Approval can be sought by anybody. Approval, setting the criminal law into motion, it can be by anybody. So this is what requires is 17A.
correct.
17A, and approval can be sought by the person who has sought to set the criminal law into
Any
motion.
person can
Any
say.
person. No officer shall investigate what is said in 17A is only without approval he shall not investigate.
Even the
He need
court-
not seek.
Where if I, as a private individual, because in a criminal jurisdiction, jurisprudence, there is no concept of locus standi. Anyone
That is-
can.
Anybody can set the
set
criminal
the
law into
motion.
motion.
But if I go before the court invoking, my lord, the powers of the court to issue process or issue a direction akin to the old section 156(3), then I'll need that approval under 17A. Otherwise, even court cannot direct.
That's all. That approval should be there for a police officer to inquire or investigate.
My lord, therefore, my lord, to be very fair, my lord, to the learned Advocate General, in his opinion, he says that, relying upon your lordship's judgment, that
That's
no.
what
it
I
is-
have myself held.
Yeah, yes, my lord, he relies upon, but unfortunately, the petitioner still my lord, continue that no, it can only be the police officer. My lord, therefore, I'm just reading that even that is considered by the Honorable Governor. Provides the police officer and not private person. Section 17A of the Prevention of Corruption Act provides that no inquiry or investigation shall be conducted by a police officer into any offense alleged to have been committed by a public servant under the PC Act without prior approval from appropriate authority. However, neither it is said that private person cannot request for the prior approval from the competent authority, nor only the investigating agency will seek the sanction from the competent authority. The only thing is to understood that the police will not inquire without prior sanction. It is important that police should start the investigation process only after getting the sanction from the competent authority. It is immaterial who does the effort to get the sanction. The decision of the Honorable High Court of Karnataka in so-and-so, Dr. Ashok, my lord's judgment.
Yes.
What more application of mind can a governor, my lord, make? He is expected to make at a 17A stage. But since it was a contention raised by the Honorable Chief Minister, he deals with this. So-and-so and various high courts, the High Court of Karnataka had issued guidelines to be followed in the cases related to prosecution of public servant for the alleged offences during the discharge of duties with a circular dated so-and-so. This circular stipulates the procedure and prerequisite for registering the cases of prosecution against the public servants. Point number 2 of the circular reads as, my lord, your lordships have read that circular, I'm not, my lord, reading. Hence, last 2 lines, the above circular of the Honorable High Court makes it compulsory that previous sanction is necessary to file a private complaint in the court of law by private persons. In view of the aforesaid, it emerges that the present situation amounts to peril of democratic principles and therefore requires independent application of mind and my subjective satisfaction and objective assessment of facts and materials provided. Since the sanction is sought against the Honorable Minister himself, Chief Minister himself, the surrounding circumstances of placing the show cause notice before the cabinet and the decision of the cabinet advising me to withdraw the notice would not inspire confidence to act on such advice of the cabinet. So why he is not following 163 is also recorded by applying mind. Upon perusal of the petition along with the material in support of the allegations in the petition and subsequent reply of Shri so-and-so and the advice of the state cabinet along with the legal opinion, it seems to me that there are 2 versions in relation to the same set of facts. It is very necessary that a neutral, objective and non-partisan investigation should be conducted. I am prima facie satisfied that allegations and supporting materials disclose commission of the offences. Then, my lord, at the end, he says 32. Hence, I hereby accord sanction against the Chief Minister under Section 17A of the Act, read with 218 of so-and-so for the commission of the alleged offences as mentioned in the petitions. My lord, petition mentioned 2 things, 17A and 218. 218 is 197. My lord, which is not the stage here.
Yes.
So this will have to be confined to 17.
197 is precognizance.
So
sanction.
precognizance after investigation.
Investigation.
And, my lord, thereafter, my lord, the order is passed based upon, my lord, this material, which is on, my lord, page 1. Your lordships were taken by my learned friend, Mr. Singhvi, to the order, my lord.
The order?
Well, the impugn order. Impugn order, my lord, but this is the impugn order, my lord, thereafter, according sanction to court. And, my lord, this is the Honorable Governor signs on 16th August 24, the entire
Yes.
detailed, my lord, consideration. And on the same date, on 16th August, the impugn order is passed according approval. And I'll show that all findings, all considerations, all application of mind need not be in the order. It should be reflected on file, and the court's conscience should be satisfied that there is an application of mind. Lord, when I am meeting with the allegation that the Honorable Governor did not apply mind, my lord, let me show something very interesting. The application of mind and why the Honorable Governor was fully justified in not relying upon the aid and advice. Well, there are 5 stages. Well, I'll just tell your lordship broadly and just show. The first is the chief secretary prepares a note that these are the facts of the case, say 40 pages. I'm giving a hypothetical, it would be 45 or whatever.
Yes.
Or 20 or whatever. Thereafter, matter goes to the learned advocate general for his opinion. The learned advocate general, my lord, obviously takes those facts as they are. I'll not say copy because we always, my lord, take the facts as given to us, my lord, from the officers. Then adds his opinion, judgments, etc., etc. That is the second stage. Third stage, the matter is placed before the cabinet. Cabinet, in this 90-page cabinet note, verbatim, with comma full stop, reproduces the opinion
The Advocate General.
of the Advocate General and the Chief Secretary. Verbatim, comma, full stop. Well, constitutionally speaking, the cabinet is collectively responsible, but this is a case of collective non-application of mind. Everyone, my lord, agreed to something which is pre-written, page to page. Thereafter, my lord, the 4th stage comes, and 4th stage is the reply given by the Honorable Chief Minister, which is cut paste from Chief Secretary, Learned Advocate General, Cabinet note. That forms part of his reply. And the last para, that in view of this, don't grant sanction. And the 5th stage, the petition contains those averments in that order, seriatim, page by page. Lord, irony, Bangalore is an IT capital of the country. There is an artificial intelligence available. They could have used artificial intelligence to at least paraphrase what is being copied. But, my lord, they say on a lighter side that artificial intelligence can never match natural stupidity. But this is, my lord, the collective non-application of mind, my lord, and I have dealt with, my lord, a reasonable application of mind by the, my lord.
This is the first
Constitution.
point,
Yes, this is my
application of
first point.
mind.
Yes.
No, I think even natural justice you dealt with or still to tell.
Yeah, no, my lord, I have something more
Yes.
to add, my lord. Lord, please come to page of my note, my lord. Please come to Lord, page 19, page 18, because my learned friend may.
Page
Give me
80.
only a minute.
Yes, yes.
My lord, my learned friend may raise a ground, a potential submission which I may deal with right now, that whatever is the application of mind should be reflected in the order itself, and you cannot justify it by file notings. The Honorable Supreme Court had an occasions to deal with such a submission.
Nambudri Park,
Yes, my lord, not required. And
1990,
yes, I'm grateful, my lord.
where the
Kindly
Supreme
have a
Court
look at
says if the reasons are found in the file notings, that would suffice.
enough.
Because it was also a case of a chief minister.
Yes, my lord. Kindly, my lord, have a look at, but just to give a flavor of the judgment,
Have the
page
judgment?
18, my lords.
Have the judgment?
No, my lord, page 18 of my note, I have quoted the relevant part.
Yes, sir.
Page 19, my lord, is the judgment, para 22.
E.G. Nambudri, yes.
Yes, AG Nambudri, my lord. It is submitted that in order to understand the reasoning of the decision to grant approval for sanction, the perusal of, this was also grant of sanction, pre-cognizance sanction. So something at a higher threshold.
After
Then-
investigation.
Yes, after investigation, 17A is at a much lower threshold. The perusal of the file is necessary. It is stated that same is a permissible mode of examination of the extent of application of mine and locating the actual reasons behind the order. In case of Union of India versus E.G. Nambudri, please turn the page over, my lord. I'll read, my lord, only what is relevant because I know, my lord, your lordships need not be bothered with what is, my lord, very obvious. Your lordships are fully aware, but only highlighted part. If any challenge is made to the validity of an order on the ground of it being arbitrary or mala fide, it is always open to the authority concerned to place reasons before the court which may have persuaded it to pass the orders. Such reasons must already exist on record, as it is not permissible to the authority to support the order by reasons not contained in the records. Like my lord Mohinder Singh Gill case, that you cannot substantiate your order by filing affidavit subsequently. But the reasons are already
So
pre-existing.
the submission is in Mohinder Singh Gill, there was nothing in the order nor in
Order?
the file. It was sought to be justified by way of statement of objections, which the Supreme Court said it cannot be done.
It cannot be done.
Now,
That-
what you're saying is that everything is in the file.
Right.
It is not that it should be in the order.
It existed when the order was passed.
Existed.
Then para 10, in governmental functioning, before any order is issued, the matter is generally considered at various levels and the reasons and opinions are contained in the notes on the file. The reasons contained in the file enable the competent authority to formulate its opinion. If the order as communicated to the government servant rejecting the representation does not contain any reasons, the order cannot be held to be bad in law. If such an order is challenged in a court of law, it is always open to the competent authority to place the reasons before the court which may have led to the rejection of the representation. It is always open to an administrative authority to produce evidence alunate before the court to justify its action. I cannot file an affidavit and supplement it by new reasons, but I can always show that reasons already existed. And summary of those reasons is
Forms the part of the order.
forms part of the impugn order. My lord, similar in case of my lord Sarath Kumar Das. My lord, kindly see only the highlighted part. The record is called to consider whether he has given due consideration to the facts placed before him before he arrives at the decision. Therefore, the reasons in the order or found from the record bridges the link between the maker of the order and the order itself or decision. Therefore, the natural justice is not a rigid nor an inflexible rule. It should be applied to a given fact situation depending upon the background of the statutory provisions, nature of the right which may be affected, and the consequences that may entail. This court held that the grading itself is a reason and no separate reason in that behalf in arrangement or that is on the facts of the case. So, my lord, it is not providing reason post decision, but showing
Reasons
something
existing
pre-decision.
pre-decision.
Then, my lord, page 22, I have quoted, my lord, again Sri Rupa. Lord, where only para 30 and 31, my lord, may perhaps, my lord, I would like
Yes,
to
sir.
assist your lordship with.
Yes, sir.
It is therefore not necessary that there should be clear incriminating evidence with the investigating officer at the stage of him seeking prior approval under 17A. Lord, here was the facts where
There, no,
he
Lokayukta was
started on it.
complained.
He started on
The
his own.
Lokayukta was, the complaint was made to the Lokayukta. The investigating officer had sought approval under 17A. It is in those circumstances it was written.
All that is required under the provisions of section 17A of the Act is that the investigating officer has some credible evidence on the basis of which he forms an opinion that an investigation is warranted. This is all the complainant needs to do, and this is all the Honorable Governor needs to examine. 31, my lord. Since the public servant is yet to be investigated, the question of considering any incriminating material and coming to the conclusion that an investigation is unnecessary would not really arise in this particular case. Since the public servant is yet to be investigated, the question of considering whether there is any incriminating material or its veracity by the state government to come to the conclusion that an investigation is warranted or not would be untenable and stand no logic or reason. At this stage, it cannot be done. He is yet to be investigated by the Lord, then page 23, para 49. The argument that the materials collected have to be considered meticulously. My learned friend, my lord, in substance, I am paraphrasing his submission, said that the order granting approval under section 17A should be akin to a judgment of the court, dealing with each and every submission made by the Honorable Chief Minister. No, this is purely an executive administrative order. It need not contain para-wise para, contention-wise contention findings, because that would be counterproductive to the very intent of section 17A. That, my lord, this honorable court says, the argument that the materials collected have to be considered meticulously as indicated by this court in so-and-so cannot be accepted for the reason that in the said writ petition, the court was considering an order of approval in that case where the order of approval merely stated that government had meticulously considered the matter by use of the term so-and-so. Thoroughly checked, my lord.
Thoroughly checked.
Thoroughly checked. The relevant portion of the order reads as follows, my lord. So, my lord, this is a 6-page order. It considers everything. And I am, my lord, showing to your lordships and in my respectful submission, my lord, satisfactorily, that there is an application of mine. My lord, now please come to, my lord, page 24. Para 28, State of Maharashtra versus Ishwar Piraji Kalpatri.
Hmm.
My lord, what documents should be scrutinized at the stage of sanction?
Sanction.
This is 19, the sanction under 19, my lord, precognizance. Another reason as given by the High Court for quashing the sanction was that the order of sanction was signed by Additional Chief Secretary to the Government of Maharashtra, but there is nothing in this order to indicate as to whether the signatory or any other officer on his part was the one who had personally scrutinized the file and arrived at a subjective satisfaction that is a legal prerequisite. We do not find any warrant in law which requires a statement being made while according sanction that the officer signing the order had personally scrutinized the file and had arrived at the required satisfaction. They might say that the governor asks someone else to prepare the charts. He can do that, my lord. Any authority can do that. That this kind of clerical exercise of bifurcating in 3 different compartments, you give it to me so that I can easily make up my mind. Then, my lord, para 12. This prima facie shows that there has been an application of mine and that the material on record has been examined by the officers concerned before according sanction. In view of the aforesaid, there was absolutely no justification for the learned judge to observe that any such statement as indicated by him was required to be made in the order. The learned single judge made observations to the effect that the manner in which the sanction order has been passed would show that a rather cavalier treatment has been meted out in the present case. We do not see any justification for the court making such observations in the present case because the perusal of the order of sanction does not show any legal infirmity, etc., etc., my lord. My lord, then on principles of natural justice, my lord, page 25, para 31. My lord, I need not read this.
Celebrated judgment, Ramji.
Yes, my lord. So I know, my lord, your lordship would be aware. I placed it for immediate reference. Your lordship may not have to try and find out, my lord. Therefore, I'm not reading it, my lord.
Para
Even-
13 of that judgment.
Yes, my lord. Yeah, my lord, we have quoted
Truly
that.
horse or
And we have quoted 24, my lord.
24.
Yes.
Para 24.
Ramji, yes, my lord, 13. I'm sorry,
Ah,
your lordship,
yes.
sorry. I'm not, my lord, then, my lord, I'm coming to the next limb that in administrative action, there is no hearing required. I have already made my submission broadly. That 17A is a stage where a very, very broad and prima facie view is to be taken. Whether it needs investigation, then you have all the remedies. Once the FIR is registered, you have the remedies and with which the approving authority, approval granting authority is not concerned. At times, it might happen that if an opportunity of hearing is read into the provision, the act, the object, intent and purpose of the act frustrates. The person might, my lord, destroy the evidence. And in any case, by the very nature of the power under 17A, which is purely executive and administrative in nature, my lord, no hearing is necessary. My lord, for that, my lord, I wish to, my lord, cite Subramaniam Swami, my lord, at page 27, para 36 at the foot, my lord. They have also cited, but my lord, this is the true ratio which is applicable in the present case, my lord. My lord, in fact, we got very substantial assistance from the judgment compilation filed by them. Para 44 of my lord Subramaniam Swami. We may also observe that grant or refusal of sanction is not a quasi-judicial function, and the person for whose prosecution the sanction is sought is not required to be heard by the competent authority before it takes a decision in the matter. This is for 19,
19.
but much higher threshold, because the court is taking cognizance.
17A was not there at all.
Was not there at all, my lord, because it was introduced in 19, my lord.
2018.
18, my lord.
Yes.
Yes, I stand corrected. I am obliged. What is required to be seen by the competent authority is whether the facts placed before it, which in a given case may include the material collected by the complainant or the investigating agency, prima facie disclose commission of an offense by a public servant. Well, this deals with the argument that principles of natural justice are attracted at 17A stage. If it does not attract, even at the stage of 19, which is a higher threshold, where the court is taking cognizance, and therefore you are now an accused. Here you are only a suspect at 17A stage. 19 makes you an accused. Even there, you are not supposed to be. It's purely executive function, administrative order. Similarly, my lord, judgment of Deepak Chaudhary, my lord, only para 5, the highlighted part,
Yes, sir.
we find force in the contention. The grant of sanction is only an administrative function. Though it is true that the accused may be saddled with the liability to be prosecuted in a court of law, what is material at that time is that the necessary facts collected during investigation constituting the offense have to be placed before the sanctioning authority, and it has to consider the material. Prima facie, the authority is required to reach the satisfaction that the relevant facts would constitute the offense, and then either grant or refuse to grant sanction. The grant of sanction, therefore, being administrative act, the need to provide an opportunity of hearing to the accused before according sanction does not arise. The High Court, therefore, was clearly in error in holding that the order of sanction is vitiated by violation of principles of natural justice. The second ground of departmental exoneration by the disciplinary authority is also not relevant. What is necessary and material is whether the facts collected during the investigation would constitute the offense for which the sanction had been sought for. My lord, similar is Ishwal Piraji Kalpatri, again, my lord, at para 15, page 29, para 15. In our opinion, there is a complete misreading of aforesaid provision by the High Court.
In
It
fact,
is-
in Veeraswamy's judgment, all this discussed.
Yes, your lordships are aware, I need not.
91, 3 SCC, I guess.
Yes, my lord, that is K. Veeraswamy, which is
Ah.
cited at para 16, page 30. Lord, your lordships are absolutely right. Page 16, foot at the
Yes,
bottom,
yes.
K. Veeraswamy case, 91, 3
Because at
SCC.
every stage of the investigation inquiry that is made earlier, so you need not go on questioning the accused or
Yes,
elicit information.
confronting him or etc. etc. It is only when the investigation starts that the investigating agency does it. The approving authority, in fact, should not do it, cannot do it, and is not expected to do it. My lord, other judgments are also, my lord, on the same line.
Yes, sir.
Only one, my lord, judgment, my lord, I would wish to, my lord, place for your lordship's consideration is at page 36. But before that, let me, my lord, give the background.
Yes, sir.
My learned friend, my lord, possibly being aware of the law on the point that even at the stage of sanction to take cognizance, hearing is not read by the Honorable Supreme Court, and Supreme Court has clearly said that no hearing is required. He attempted to come out of that line of judgments by saying that in Rajesh Agarwal, Now, after reading Maneka Gandhi, etc., the law is that hearing is required. My lord, I had an occasion to assist the court in that judgment, my lord. My learned friend was opposing me. Where, my lord, the facts were, there is an RBI circular. RBI circular provides for various steps to be taken by the banks to find out
Before you declare one as willful defaulter or a fraudulent.
or a
defaulter.
fraudulent defaulter, because I may be in a genuine financial difficulty or I really had an intention to cheat. And the consequences where if I'm declared as a fraud account, then other banks will not lend me no loan. My other accounts would automatically become NPA, etc.
Serious economic consequences.
Consequences. The court bifurcated its judgment in two categories. A, the civil part of it, that when you declare somebody as a fraud not as understood in the IPC or now BNS, the fraud in the commercial banking sense of the term. And thereafter, there are some civil consequences because you go for statutory audit, you go for forensic audit, there are several things, etc. And therefore, you must associate him, because without which forensic audit is also not possible. Forensic auditors also would need your books of accounts, your vouchers, etc., etc. Therefore, the court said that you must hear him. But the second category, second option in the resolution, in the RBI circular was that this is okay, this is civil part of it, but you can also register an FIR. And the argument was that when it is question of registration of an FIR based on something fraudulent in this banking transaction, I should be heard. Lord, I raised the contention that there is no concept of hearing so far as invoking criminal investigation power is concerned. And my lord, I believe inadvertently my learned friend, my lord, missed that part of the judgment while citing page 36, my lord. Para 42.
Before FIR is lodged and registered.
No opportunity of being heard is required before an FIR is lodged and registered. My lord, we are dealing with 17A, which is a scenario prior to registration of the FIR. So at the stage of FIR also, you are not supposed to be heard. Where is the question of giving a hearing pre-FIR stage, where I am only prima facie considering whether to permit you to register an FIR or not. Lord, this in my respectful submission, in all fairness to the court, ought to have been pointed out while relying upon my lord Rajesh Agarwal. Because in fact, I am relying upon it. Now, my lord, page 37, non-supply of other two petitions does not invalidate the order. My lord, I have already said, hearing being not a prerequisite, merely because in one case show cause notice is given, other two cases which are not dealing with any different, distinct or completely a different offense, they are the same. So there is therefore the governor says that give me the comparative chart, whether there is any difference. If one allegation is some defalcation in Mysore and another in Bangalore, with different set of facts, different particulars, different authorities involved, different officials, connivance with different people, beneficiaries are different, then my lord, maybe he may have
In fact, the
issue.
governor says everything is the same.
is the same.
Same.
So you can't
There is no
take
difference in facts.
Yes, my lord, when the facts are same, then what is I'm posing a question to myself, prejudice cause. Whatever was against you was given to you, though was not required to be given to you. But nonetheless, in all fairness, the Honorable Governor gave it to you. Two other persons have also said the same thing, which you were not given, but your answer is on the same issue, same allegation, same set of facts, same beneficiaries, same documents. Therefore, my lord,
So
there is no
Are you,
prejudice.
are you going to Karnataka?
I'm going to
Prejudice.
yes.
No prejudice. cause.
Yes, my lord. I am page 13. I have my lord. I can't match your lordship's speed, my lords, and knowledge both, my lord. Your lordships are aware, my lord.
94-1074, where Supreme Court says prejudice should be first established. There it was established, is said, because inquiry officer's report which was against him was not given.
Was not given.
Pursuant to the 42nd Amendment, that was the interpretation made. That's.
Here, my lord, there
that's
is no prejudice cause. Even if, my lord, all three complaints were not given to him and no show cause notice, and the order of approval would have been passed, it would have, my lord, withstood your lordship's judicial scrutiny. So, my lord, that is the judgment. Another is Haryana Financial Corporation, Kailas Chandra.
And that is following Karnataka.
Yes. My lord, then, my lord, I am on aid and advise
Huh.
at page 41. My lord, kindly read 164.
Madam. Constitution.
Page 41.
Page 44.
Page 41, my lord.
Yes, sir.
My lord, while my lord, the proposition is when the Honorable Chief Minister is a potential person to be investigated, the aid and advice of his counsel cannot be, in constitutionally speaking, taken, my lord. And the answer is 164, apart from the judgments. Other provisions as to ministers. The chief minister shall be appointed by the governor, and other ministers shall be appointed by the governor on the on the advice of the chief minister. So I, as a minister, owe my ministership to the honorable chief minister. It's from Caesar's to Caesar's right. This is one example where without any hesitation, one can reach a conclusion that in this case, the governor cannot even look at the cabinet note. Though he looks at it, examines it, records a finding that I should not rely upon it, both in law and on account of bias. And therefore, my lord, he chooses not to rely upon it. Please see, my lord, the judgment. My lord, before that, my lord, kindly see para 55 at the foot, my lord. It is further submitted that in accordance with Karnataka government transaction of business rules, specifically rule 20 and 28, it cannot be said that the petitioner did not have any influence over the meeting convened to decide whether sanction may be granted against the petitioner. A simple reading of Rule 20 and 28 of the rules would make it clear that the petitioner enjoyed an overarching influence on his cabinet colleagues. Rule 20 reads thus: cases specified in the first schedule to these rules shall be brought before the cabinet after submission to the minister in charge of the department. Cases other than those specified in the first schedule to these rules shall be brought before the cabinet by the direction of the chief minister. It goes to him, his file, whether the cabinet should aid and advise the governor will go to the chief minister first. Then two, the minister in charge of the department with the consent of the chief minister. He has an overarching power. That then, my lord, at the foot, the decision of the chief minister regarding requirement of approval of cabinet shall be final. He is the final authority, and it is not enough that he did not participate in the meeting of the cabinet, because the process requires his participation. It is he who decides to send it to the cabinet. Merely because he abstains from that particular meeting will not meet the ends of justice. This is without prejudice to my submission that irrespective of this, in case of an honorable chief minister, the governor is not supposed to act as per the aid and advice of the Council of Ministers. Then, my lord, 28 at the foot, Rule 28. The chief minister, or in his absence, any other cabinet minister nominated by him shall preside at the meeting of the cabinet. So merely because he was not present doesn't absolve him of a possible bias, because it is his own representative, someone nominated by him, who will be presiding over the cabinet. And the cabinet, my lord, and my lord, in his own reply, page 630, annexure F, says,
Yes, sir.
So please come to page 630, annexure F,
Yes.
para 3 at the foot, last two lines at the bottom.
I have recused.
I have recused myself from the meeting, and in terms of Rule 28 of transaction of business rule, nominated Dr. D.K. Shivkumar, Deputy Chief Minister, to chair the meeting. So his representative was chairing the meeting. And he nominated him, my lord. That is at page 269, my lords. Page 269, para 4. The Urban Development Secretary, my lord, writes this, para 4.
Approval of the consent.
Yes, but this is covering later to the cabinet.
Yes.
In background of the above as directed by the Honorable Chief Minister under Rule 20 of the rules, the matter has been placed before the cabinet for deliberation. Lord, your para 269, your lordship.
Para 4 there.
Para 4, my lord.
Yes.
The entire exercise, my lord, he is involved. Now, my lords may kindly see, my lord, at the cost of repetition also, Special Police Establishment Act. My lord, para 16 refers to Cry Park judgment, my lord.
Yes.
All of us have, my lord, read
Yes.
and reread. Kindly come to page 44, para 17. On the basis of the ratio in this case, Mr. Sorabji rightly contends that bias is likely to operate in a subtle manner. Sometimes members may not even be aware of the extent to which their opinion gets influenced. In light of the then, my lord, kindly come to 62. My lord, I am reading Samser Singh para first, and
Yes.
then come back to MP judgment, my lord, because my learned friend also read Samser Singh, which is pre-MP judgment, my lord.
Yes.
Para 154. We declare the law of this branch of our constitution to be that the president and governor, custodians of all executive and other powers under various articles, shall, by virtue of these provisions, exercise their formal constitutional powers only upon and in accordance with the advice of their ministers, save in few well-known exceptional situations, without being dogmatic or exhaustive. These situations relate to A, the choice of prime minister or chief minister, restricted through this choice is by the paramount consideration that he should command a majority. B, the dismissal of the government which has lost its majority in the House but refuses to quit office. C, the dissolution of the House where an appeal to the country is necessitous. Although in this area, the head of the state should avoid getting involved in politics and must be advised by his prime minister, who will eventually take the responsibility of the step. Lord, the Honorable Supreme Court says this is not an exhaustive list. So this judgment will not come to the help. The judgment, real judgment is MP judgment. Again, my lord, which I have reproduced in this chronology.
Yes.
Please come to para 12. Para 8 first. The question for consideration is whether a governor can act in his discretion and against the aid and advice of Council of Ministers in a matter of grant of sanction for prosecution of ministers for offences under the Prevention of Corruption Act and or under the Penal Code. This is 190, this is 19 sanction.
19 sanction.
Thus, as rightly pointed out by Mr. Sorabji, a 7-judge bench of this court has already held that the normal rule is that the governor acts on the aid and advice of the Council of Ministers and not independently or contrary to it. But there are exceptions under which the governor can act in his own discretion. Some of the exceptions are set out here in above. It is, however, clarified that the exceptions mentioned in the judgment are not exhaustive. This is by referring to Samsher Singh, my lord. Therefore, my lord, I choose that chronology. First MP, then Samsher Singh, then again MP. Some of the exceptions, it is, however, exhaustive. It is also recognized that the concept of the governor acting in his discretion or exercising independent judgment is not alien to the Constitution. It is recognized that there may be situations where by reason of peril to democracy or democratic principles, an action may be compelled which from its nature is not amenable to ministerial advice. Such a situation may be where bias is inherent and or manifest in the advice of Council of Ministers. The governor, my lord, in the present case records that the note, the cabinet note is biased. And that cannot be questioned, my lord, by the accused, my lord, in a writ petition. Then 19, Article 163 has been extracted above, undoubtedly in a matter of grant of sanction to prosecute. The governor is normally required to act on aid and advice of the Council of Ministers and not in his discretion. However, an exception may arise while considering grant of sanction to prosecute a chief minister or a minister, where as a matter of propriety, the governor may have to act in his own discretion. Similar would be the situation if the Council of Ministers disable itself or disentitles itself. The governor also records by their conduct, they have disentitled themselves. And propriety also demands, democratic principles demand that I act on my own discretion. Mr. Tankha is not right when he submits that the governor would be sitting in appeal over the decision of Council of Ministers. However, as stated above, unless a situation arises as a result whereof the Council of Ministers disable or disentitle itself, the governor in such matter may not have any role to play. Taking a cue from Antule to so-and-so, it is possible to contend that a Council of Ministers may not take a fair and impartial decision when their chief minister or other members of the council face a prosecution. But the doctrine of apparent bias, however, may not be applicable in a case where a collective decision is required to be taken under a statute in relation to former ministers. In a meeting of Council of Ministers, each member has his own say. There may be different views or opinions, but in a democracy, the opinion of the majority would prevail. But here, my lord,
but
collectively,
when-
unanimously, they have, my lord, taken the same view, my lord, without applying mind, they have adopted some view. There is one author, and if I may say so, my lord, subject to being contradicted, which I don't think they will be able to, even the printer and the fonts are same. Like, anyway, that's not
No,
my
but,
ground.
in a scenario where sanction earlier, approval now is sought to not to prosecute, to register or investigate into the affairs of chief minister. It is only the governor who has to independently apply the mind.
Apply
It's
his
not,
mind. He cannot, my lord.
no, even while considering sanctions, Supreme Court has said that when it comes to the chief minister, it is the governor's independent application of mind that is necessary and not on the aid of the ministers. I'm
Correct.
correct. That is what, there are 4 or 5 instances where the chief ministers were sought to be prosecuted and sanction was sought.
Correct.
Then aid of the ministers would not.
It's not required.
Cannot be taken. Is it?
Not only, he cannot take it. Even if he wants to, he should not take it.
But I feel judgments should be there, I guess.
Yes.
Yes, sir.
Yes, ma'am. If on these facts and circumstances, the governor cannot act in his own discretion, there would be a complete breakdown of rule of law, in as much as it would then be open for the governments to refuse sanction in spite of overwhelming material showing that a prima facie case is made out. If in cases where a prima facie case is clearly made out, sanction to prosecute high functionaries is refused or withheld, democracy itself will be at stake. It would then lead to a situation where people in power may break the law with impunity, safe in the knowledge that they will not be prosecuted as the requisite sanction will not be granted. So then next page, bold part. However, on those rare occasions where the facts on the bias becomes apparent and or the decision of the Council of Ministers is shown to be irrational, there is a specific finding of the governor that because of these reasons, the cabinet note is irrational. And based on non-consideration of relevant factors, the governor would be right on facts of that case to act in his own discretion and granted sanction. Lord, this is the Constitution Bench judgment, my lord. And thereafter, your lordships would find Ramdas Nayak, my lord, at page 49.
That is where I think Supreme Court says that when it comes to the sanction of the chief minister,
Yes.
I think governor should act if
Yes,
I'm right.
that is page 49, my lord. para
It is
67.
Abdul Rahman Antule.
Yes, yes, RS 9. My lord, only highlighted part I may read, my lord, because, or my lord, let me read the full. We may add, there is nothing before us to think.
Where
that-
are you reading?
Page 49, my lord, I'm sorry, page 49. Para 67. But the judgment, para 10, I am reading.
Yes, yes.
We may add, there is nothing before us to think that any such mistake occurred, nor is there any ground taken in the petition for grant of special leave that the learned judges proceeded on a mistaken view that the learned counsel had made a concession that there might arise circumstances under which the governor, in granting sanction to prosecute a minister, must act in his own discretion and not on the advice of council of ministers. The statement in the judgment that such a concession was made is conclusive, and if we may say so, the concession was rightly made. In the facts and circumstances of the present case, we have no doubt in our mind that when there is to be a prosecution of the chief minister, the governor would, while determining whether sanction for such prosecution should be granted or not under Section 6 of the Prevention of Corruption Act, as a matter of propriety, necessarily act in his own discretion and not on the advice of the Council of Ministers. Yes, Your Lordship, sir, my lord, I'm grateful. Now, my lord, my learned friend unnecessarily confused Nabam Rabia. The way he read, Nabam Rabia is helping me. But I'll show, my lord, how it helps me. Most of the judgments, my lord, cited by him helps me. Please have a look at this Nabam Rabia. Nabam Rabia was a case under Schedule 10, the defection provisions, my lord, and role of the governor vis-a-vis, my lord, other constitutional functionaries. Now, my lord, please see. Nabam Rabia refers to MP judgment and affirms it. My lord, this is Justice Kehar's view for himself, Ghosh and Justice Ramanna, and others have concurred. It is a constitution bench. All have concurred, but they have separately recorded concurring views. But this view of my Lord Justice Kehar is for 3 honorable judges. We may therefore summarize our conclusions as under. Firstly, the measure of discretionary power of the governor is limited to the scopes postulated, therefore, under Article 163(1). Secondly, 163(1), the discretionary power of the governor extends to situations wherein a constitutional provision expressly requires the governor to act in his own discretion. We are not concerned. Thirdly, the governor can additionally discharge functions in his own discretion where such intent emerges from a legitimate interpretation of the provision concerned, and the same cannot be construed otherwise. This is important. Fourthly, in situations where this court has declared that the governor should exercise the particular function at his own and without any aid or advice because of impermissibility of the other alternative by reason of conflict of interest. After relying upon MP judgment, another constitution bench judgment is pleased to say this, my lord. Then concurring view of my Lord Justice Lokur at the foot of page 50,
Yes.
para 362. The development of constitutional law in India and some rather peculiar and extraordinary situations have led to the evolution of a distinct category of functions in addition to those postulated or imagined by the Constitution and identified above. These are functions in which the governor acts by the Constitution and of the constitutional necessity in view of the peculiar and extraordinary situation, such as that which arose in MP Special Police Establishment Act, cited and approved, and as arise in situations relating to Article 356 of the Constitution or in choosing a person, etc., etc. My lord. My lord, similar is the view in concurring judgment, my lord. Last, Nabam Rabia does not dilute this. And my lord, Nabam Rabia also, my lord, my learned friend had the honor of assisting the court. So was me, my lord. I also assisted the court. So I am aware, my lord, this is not diluted because constitutionally speaking, it is not capable of being diluted. Then likelihood of bias in the decision of the cabinet, my lord. I have cited judgments, my lord. I may not.
Reasonable man's theory.
Yes, my lord. Lord, time taken during grant of approval for investigation, Lord, they say that I acted hurriedly. Lord, please, Lord, see, I have shown, Lord, the list of dates which I have taken from their record only. And Lord, please allow me to read this para, Lord, so that there is no hurry, undue hurry or something, Lord. He attended to, within 2-3 days, issued notice, heard, then charge prepared. It's not as if, Lord, I received the complaint today and I grant approval today. Lord, sometimes, Lord, what happens is, when we are dealing with constitutional functionaries, our pleadings as well as our submissions must express that respect. Lord, to show that friendly governor or the respondents have given comical replies, Lord, does not behove a constitutional functionary who is the Honorable Chief Minister. Lord, I didn't say anything against the Honorable Chief Minister because he's a constitutional functionary. There can be several adjectives I can use. Merely because some individuals have filed a complaint, they do not become subject matter of a laughter or you being Lord, labeled as comical or something. But please see, Lord, on this, it is submitted that petitioner has raised the false issue of issuance of a show cause notice dated so-and-so on the same day as the receipt of petition of respondent number 3 seeking grant of sanction for prosecution. In this regard, it would be relevant to point out that the Honorable Governor was made aware of larger issue with respect to rupees 4,000 crore scam in relation to the irregularities in allotment of land by MUDA much before the issuance of show cause notice. In order to discharge his duties as the head of the state of Karnataka and to ensure that the government was working in accordance with the constitutional principles, the Honorable Governor deemed it fit and appropriate to seek a detailed report from the Chief Secretary of the Government of Karnataka. In furtherance of the aforesaid, the Honorable Governor wrote 2 letters dated so-and-so. My Lord, they have filed in the petition. I am not, my Lord, placing any other document on record. That is 5th July and 15th July. In reply to the above referred facts, the office of the Honorable Governor received a letter in the form of a report from the Chief Secretary of the Government of Karnataka dated 26th July 24. That is again placed by them. It is submitted that the narration of facts in the said report is verbatim and factual narration in the decision of Cabinet.
Yes,
My Lord, your Lordships are at page 54. My Lord.
yes, yes.
Cabinet dated 1/8/24 and the reply of the petition. So it was going on. He was seeking information, and at that stage, Mr. Abraham came in person. He was examined. His authenticity, his identity was, my Lord, established. And my Lord, immediately the notice was issued. My Lord.
No, but
Me-
whether a decision taken in hottest haste, would it vitiate the entire thing?
Thing, my Lord, when mere issuance of show cause notice would not show undue haste, because thereafter he gave
So
sufficient time.
this is show cause notice, a little step further also.
Thereafter, my Lord, there are.
If a decision of
Yes.
the state is taken in a hottest haste,
Yes.
whether that would completely vitiate the entire.
It cannot
decision.
vitiate, my Lord. Sometimes, as a constitutional functionary entrusted with the constitutional power, it may be required that the moment he comes to know about it, he has to immediately approve
No, this, yes.
investigation. That yes, I am passing 17A, you start immediately. This cannot brook delay. Sometimes a delay may result in, my Lord, an allegation of his dereliction of. Then, my Lord, I have already said the contention that I have not taken any decision, I have not made any recommendation. Then why are you bothered? Then you are like any other ordinary offender. Then 17A is not required. Then why should you challenge the approval? You say that 17A is irrelevant. 17A cannot be relied upon because I have not taken any decision. I am not going into the facts where his role comes, how he benefited himself comes, how the Prevention of Corruption Act is, its architecture is couched. Even the beneficiary is an offender. That etc. etc. But it would be premature for me to arrive at any conclusion, record any conclusion, or argue before your lordship. I have only said that yes, needs investigation, you investigate. my lord, these are my respectful submissions, my lord,
Yes.
and I have, my lord, even judgments on this
Yes.
point, my lord.
I'll,
So,
it's quite elaborate and it's,
my lord, I'll not, my lord,
yes.
trouble your lordships, my lord. Kindly treat them as read.
Constitution bench judgment.
Yes.
Justice Y.K. Sabharwal, I think, 2004, 3 SCC. Even a decision, not this is only a notice being issued. Even a decision taken in hottest haste would not vitiate the
Yes,
decision.
I am aware of it, my lord. I'll just.
Says that went from this state where KADB allotments were made in hottest haste. That was some, it starts with SP or something. Justice Y.K. Sabharwal.
I'll find out and place for my lord's kind
Yes.
consideration. My lord, it was really pleasure and privilege to assist your
Sorry.
lordship. Obliged to your lordship.
Yes.
My lord, these are the full
Ah,
text of
yes.
the judgments which I have
Need
already
that.
cited, man. I'll give the copies to my learned. Lord, can your lordship pardon my absence only for
Yes,
5-7?
yes. Madam. ಮತ್ತೆ ವಾಪಸ್ ಕೊಡ್ತೀನಿ.
May I start?
Yes, sir.
My lord, I
Sir,
beg to
you are
appear
appearing
for
for the
respond number 4, my lord.
respond number 4.
And I will not take much time because, my lord, your lordships have heard it repeatedly by various persons. My lord, only thing is Mr. Raghavan, my lord, was to be here. He's not here. He'll just supplement, my lord, with your lordship permission for 4 on Monday. My lord, I have a very humble submission, my lord, from the different perspective. From the perspective of a complainant, my lord, who feels aggrieved by the violation of the public trust in a democracy by this process, my lord. Before I begin, my lord, just make a note of 3 figures.
Yes.
The 3 figures, my lord, in my respectful submission, which falls for your lordship's kind consideration, is 3,24,000, 3,24,000,
Huh.
5,98,000, and approximately 55 crores.
Yes.
The land in question, and I'm arguing, my lord, from the facts which have now come from their repeated same note. And they clearly inform this honorable court in the papers that the land of 3 acres plus 3 acres, 16 guntas, which became a part, and this is something important, became admittedly a part of an acquisition process which commenced in 1992.
Land was acquired?
Land was, their case is that it should release. My complaint, it should acquired, could not have been released. Everything is void. But before that, my lord, to say, my lord, that when we are in 226, whether he filed it or I am standing here, but your lordships are having jurisdiction under 226 for investigation into apparent corruption, should not get, my lord, restricted by any objection, technical or otherwise. I'll come to that, my lord, in Mulayam Singh Yadav's case, my lord. I'll show to your lordships in no time. My first respectful submission, I said, submitted, my lord, land approximately 3 acres, 16 guntas. And I, my lord, these facts are admitted, and wherever they are not admitted, they will be my submissions. Part of a acquisition process for some third phase in this scheme, my lord, in 1992. Any sale or transaction after this, my lord, notification which is issued in 1992 is void, except for the fact that a purchaser who's a bona fide purchaser, my lord, in a lawful manner may claim only compensation. Something more, my lord. A subsequent purchaser who may just get into the shows only for compensation, can't even ask for challenge to acquisition, can not get any benefit of any land policy or an alternate land. Supreme Court has directly decided it. Therefore, the land acquisition process having commenced in 1992, concluded, my lord, the final notification in August 1997. Possession taken, and I am going to cite, my lord, Indore development on 2 aspects. What is the concept of possession taken and what is the concept of compensation paid or deposited. Few paragraphs. But the relevant facts are 92 first notification, 97 final notification, land acquired, possession taken, and something more important. Please make a note of page 94 of the writ petition document filed by them. The revenue record records the MUDA as the owner in 98. Page 94.
Yes,
My lord, in the middle of the paragraph, in the middle of that page on the top, your lordship will see the ownership and possession of MUDA.
page 94.
Page 94, my lord, in this table here.
Yes.
I can't read it, my lord, I
No,
have
that's
the
all right.
handicap.
Yes,
But this is where MUDA is recorded. This is 98, 99.
yes,
And my lord, compensation, my lord, is determined. Award is made.
yes,
So first notification before May 1998, which is the so-called denotification. First notification 92, final notification 97, award 1998, and my lord, entry of revenue record 98. Therefore, why investigation needed? There is a colossal fraud, my lord, of creating a case for release of the land under section 48. 48, my lord, whatever little I know and I've learned, my lord, with the moment possession is taken, even on a paper possession, the land acquisition is complete, the land vests in the government. Thereafter, 48 is not available. I'm not saying, my lord, I'm not arguing to justify that some 48 is illegal. I am, my lord, as a citizen is praying and a justification with material on record, now confirmed by them of an investigation. So 3,24,000, where all this facade, my lord, is ex officio fraudulent. And the Supreme Court says any transaction after section 4(1), that is the first notification, renders every transaction thereafter void except entitlement to receive compensation. Now, my lord, see what happens. So the land, my lord, which stood recorded in the land revenue record in the name of MUDA in 98, admitted next fact. Even when their grievance is, even when then it is, there is a release notification, it is not released, it is developed as a development. My answer, my lord, as a citizen is, this was never released. It could not have been released. Therefore, it continued to remain in possession of MUDA. It continued to remain a part of the development scheme. Plots developed, sold from 2001 to 2004. Plots developed on this land, acquisition completed in 98, award made, compensation deposited, etc. I will come to one more document. Development completed, plots sold by written document, my lord, the learned AG was a little uncharitable in his note saying it's only a paperwork. My respectful submission is the entire thing to the contrary is paperwork. So 2001 to 2004 plots, sale deeds are in existence. Sold. Now, my lord,
the very same lands.
very same land, admittedly, it is no more remain, and I am having one more grievance, my lord. In the cabinet note, a writ petition order is cited. The writ petition order, particulars of the writ are not given. Order is not shown. And the foundation is made for giving these 14 sites to the petitioner's wife on the ground that High Court has passed an order of a same nature in a similar case. So I had the curiosity, where is the judgment? Let us see this judgment. In, my lord, 5 notes of the same kind. Fortunately, my lord, somebody gave the number. I've got that order. Kindly give the copy, sir. Udhar bhi do. This is the order, my lord. I showed to your lordship as a part of the cabinet note, part of the opinion. In, my lord, at some place, number is given in the opinion, number disappears. The read number disappears. The name disappears. Similarity remains. Now, what is this case? Somebody,
This is all the order?
this all is the order. I'll show to your lordships. Just give me one moment, my lord. I want to say something. This is available, downloaded from the High Court site, my lord. I'll show that, my lord. In any case, they will have something more. Somehow you have to justify this release. Right, my lord? Which release is ex officio, my lord, prohibited by law. Could not have even been thought of for without fraud, my lord, without fabrication, this could not have been executed. Right, my lord? So somehow justification is to be made. So some Babu who must have prepared a note, took the, my lord, risk of mentioning the writ number and the date of the order. Somebody must have advised her, make it as a part of justification. This land, my lord, was never a part of any acquisition process. Never.
But the subject lands were.
In my case, it is land acquisition award made. I say, sir, I'm coming to the notification, don't worry. This is the parity shown. And this one-page order, my lord, which the details are missing in the legal opinion, is in a case, my lord, because somebody could have easily understood it is no parity at all. If you cite it and give the particular, somebody reads it, he will shout like me. And I'm shouting. Because nothing becomes available without shouting nowadays.
Not everywhere, not necessary, sir. Yes.
After shouting also, no. You're confident? Very well. So, my lord, no acquisition process at all. It was a clearly an infraction of Article 300 capital A. Somebody includes your land without even putting it in the notification. So the High Court says, return the land. You're not acquired it. You are free to acquire it. Obviously, if you need it, becoming a part of any scheme, acquire it. Free to acquire it. You never put it in any acquisition. There is never any award. You have included into your development. Please release it. Release in the sense, not 48. Give it back. Restore it, restitute it. There is a difference between release and restitution. This is not a parity. Now please see the pages. Second volume of the writ petition. And my lord, my respectful submission is not, my lord, to create a sensation or something. Mine is that it requires investigation. Now kindly see, my lord, first of all, page, my lord, 275. This is a part of my dear friend, my lord, my dear friend's client, my lord, Shashi's client, who have given a note, the Cabinet Secretary on 26/7/24. Right, my lord?
Yes.
At page 275, please make a note of para 24. I'll just read this for crisp and, my lord, sweet short lines. In a similar case, the land of Shrimati so-and-so, Mysore Taluk number so-and-so, detail of the land is given, had been developed for layout without following land acquisition process. So, my lord, please see. Supposing I say the land is never put to any process of acquisition, it is one thing. Not following the process of land acquisition process in accordance with law is another thing. It is a case where there is no land acquisition process initiated. And please see the next line. Petitioner had filed a writ petition and order dated 22/1/20. The Honorable High Court has directed no mention of any number with writ petition. Who directed, when directed, nothing. Now, my lord, just go to this, my lord, second similar thing, my lord, at page 289.
Yes.
It is, my lord, the part of the learned AG, my lord, Shashi's opinion, which starts at 279. And kindly see para 6.24.
Yes.
Now, my lord, supposing with this order, which I handed over to your lordships,
Yes.
a meeting has to take place to comply with that order or to challenge that order. So meeting must have taken place. Now, my lord, this meeting or this order had nothing to do with the present case. And this order meeting is that it is never become a part of any acquisition process. Therefore, you are violating its fundamental right of ownership. Return it or you acquire it. Now, my lord, after this, your lordship may kindly come to page 352. Which, my lord, is a part of yes, my lord, at page 336, the reply, the cabinet meeting, my lord, the cabinet note
Part of
the
the cabinet
to
note.
the show cause notice, my lord. Kindly see this starts at 336
Yes.
and kindly come to 352 5.24.
Yes.
May I read this, my lord, with your lordship
Yes.
permission, one paragraph. In a similar case, the land of, so my lord, first 5 lines are verbatim, which I read the note earlier. But somebody forgot that this number is to be removed. And my lord, this is repeated, there is no number, etc. And then your lordship may kindly come to page 352. My lord, the writ 5.24, writ petition number 56604, and the date of the order which I have handed over to your lordships.
Yes.
So when somebody, my lord, in a routine prepares the note, the numbers come, details come, because the parity is the founded, it is one of the main documents for giving this order,
Take the copy.
for taking this decision. That the way you have returned that land of 2 acres and some guntas, please return this also. That was never a subject matter of any land acquisition. This is land acquired, award made, entries made in the name of the government, etc. Now something more, my lord, something very curious. Kindly come to, my lord, page 509 and 510.
Yes.
509 and 510. Please mark the date, my lord. So a
Please.
cabinet note is to be prepared and some justifications are to be created. So, my lord, such kind of vague documentation is generated, engineered, and I would not say fabricated at this stage, because that would be a subject matter of investigation. I would say generated and engineered, because that may not sound comical, my lord. It may still be very respectful. So it's engineered, and this engineering is here. It's a classic piece of engineering. What is that? Sir, we took the possession, we completed the process, but money was not taken by him. The compensation money. My lord, I can't read this. If your lordship may kindly have a look at that. I am told, my lord, it says, उसने पैसा नहीं लिया. Therefore, in no development, पैसा लिया नहीं लिया, land acquisition process is complete.
नहीं पैसा दिया है लिया नहीं है.
पैसा दिया उसने लिया नहीं. So that indoor says nothing. It's complete. That is why I said I am going to cite 2 paragraph C, both, my lord, for the completion of the process, kabza taken, possession taken, and, my lord, the money tendered or money even kept aside. Straight away, my lord, now 509 and 510. And, my lord, your lordship may just make a note along with this. This is 4 July. This is 1 day before page 597.
597.
Yes, my lord, 597. Now, whether it is because this is 5th July. 5th July, my lord, it is sent. So, my lord, the whatever is to be done is to be done. I am not saying it is antedated. This letter, my lord, at 510, 1 day before this letter is received from the Honorable Governor, it would be investigated. Right, my lord? So I gave your lordship two figures, my lord. 3,24,000. And my lord, when this has all happened up to 2004, the land stood developed. The sale deed for the developed plots executed. 2004, a sale deed takes place of agriculture land which stood developed and became non-existent. Because, my lord, the land is developed and the plots are sold, there is no agricultural land left.
No, how did it become agricultural again?
Oh, that's the magic.
Oh, there's no order for that.
I hope that if your lordships are convinced, my lord, the investigation must take place, the IO should be equipped enough to find out. Or I'll only pray to the Almighty.
Yes.
No, but kindly see, my lord, it's a very serious issue. My lord, it is thought to be trivialized by this repeated process of repeated notes. And when the Supreme Court says the governor will act independently, a resolution passed to pressurize him by the cabinet. Kindly see, my lord, the impact of it. You are not supposed to do it. You are not permitted to do it. And you do what the law forbids to you to do. And how? As a cabinet. And then we, my lord, keep on banging, my lord, the doctrine of public trust. This is what public trust is, with which we are faced. And, my lord, it may, our replies and our demand may be sound too comical to the other side. But, my lord, if in this case, we are not able to persuade your lordship to discharge your lordship duty as a court, which I will show, my lord, then it may be tragic, if not comical, as my learned friend used repeatedly. What is to be done? An investigation. Supreme Court says no objections to be allowed to come in if it is investigation, provided you are prima facie satisfied. My lord, even for framing of charge, my lord, which is after the cognizance and after section 19 and 197 stage, even for framing a charge, one judgment, I'll give it to your lordship, my lord, weaker than prima facie case. Strong suspicion, reasonable suspicion, etc. Supreme Court went to the extent of saying weaker than prima facie case, even for framing a charge. Here I'm saying, my lord, ex facie, established case, acceptance of the Honorable Court for facilitating and permitting the conduct of an investigation by an independent agency. Number two, my lord, when unison replies by the government, by the cabinet, by the law authorities, how would this investigation be done by any state authority? They have taken a stand before your lordship, which is unison. I'm with utmost responsibility saying unison. It is verbatim the same. So if I am right, my lord, in begging that it needs an investigation, it can't be either by them or by my learned friend, Mr. Chachi. Now, my lord, in this background, kindly come to a couple of judgments. First of all, on the public trust doctrine.
You have your written submissions also?
I will, my lord, I've got it. Some corrections are to be made. Before I leave, my lord, or by tomorrow or day after tomorrow, early morning, it will be available.
Yes.
I have also taken the liberty of reproducing the relevant paragraph so that
Yes, yes,
this, my lord,
no, all that you submitted now. If it is in the written submission.
unfriendly, my lord, environmental behavior of ours may, my lord, get restricted. Now, my lord, first judgment which your lordship may kindly see. अरे दे दो ना यार, ड्रॉप कर दो. नहीं, वो भी दे दो, सॉफ्ट कॉपी भी दे दो. मतलब this is 1994 supplement 2 SCC 116.
Yes.
Where, my lord, the grant of consent was sought to be withdrawn, where, my lord, also happened here day before yesterday. I have yet to see your lordship judgment in the other case, my lord. I just wish to read, my lord.
Division. I thought what I heard. Yes, yes.
My lord, kindly come to page 8, para 15.
Yes, I am there.
I'm sorry, my lord.
I am there.
There also, my lord, my lord, I will only leave the para number, which also, my lord, I have experienced is not needed to be given here.
Yes.
Even if we don't leave the judgment without number, anything will work. The way, my lord, the denotification has worked. No number, nothing denotified.
Yes,
Now, my lord, para 15, your lordship may just mark it.
yes.
Then kindly come to the second judgment, my lord, we need and your lordships have
Yes,
dealt
yes,
with.
yes,
Your lordships have dealt with, my lord.
yes.
And kindly only make a note of para number 52.
Actually 56.
54 to 56, my lord, if your lordship.
56 is what is.
Yes, my lord, your lordship, right, 52 to 56 are citing, but your lordship may kindly restrict it to para 56.
Yes.
Then, my lord, one paragraph which I wish to read, which is at page 64 of this paper book, is not that, my lord, Mohammed Ramdan Khan inquiry report, my lord, that constitution bench under the Central Tribunal Act, my lord, Karunakaran.
Yes.
This is the similarity of name with a greater population country where names are common.
Yes, this is
In-
K Karunakar.
So,
That is
my lord,
B Karunakar. Yes.
my lord, in my community that we have so much of shortage of names, my lord, that the girl and the boy will have the same name. So 140 crore people, they find it difficult to have the.
My learned friend, my lord, who was my colleague, Mr. Maninder Singh, Additional Solicitor General, and we had Mrs. Maninder Singh Acharya as Additional Solicitor General. Even
That's why this
in
is-
case of Navjot Singh Sidhu, his wife is also Navjot Kaur Sidhu.
So this only shows, my lord, a common feature in our society of shortage. 8, my lord, para 8.
Yes, sir.
And first 5 lines, para 8, my lord, that if a case is made out for any, my lord, investigation, then there should not be permissibility for any technical or other opinions. Court would, my lord, discharge its duty that which, my lord, would facilitate and, my lord, ensure that the investigation is carried out. My lord, I can pause here for a moment, my lord. The learned solicitor has
That
explained.
case of the Kerala Chief Minister, K Karunakar.
Yes, my lord. I just want to take 1 minute here, my lord. It is not needed. But, my lord, your lordships have seen, your lordships have gone into these 2 judgments, my lord, which have now become the foundation of the circular, my lord, of your lordships High Court, which have gone. I just want to say one thing, my lord. It may also, with the development of law on section 17A, it may, my lord, require a little tuning, etc. Because I tell your lordship why, my lord, what I feel and very humbly submit. My lord, the preliminary inquiry, my lord, as we know, in the ordinary normal state police, it is FIR under the CR. Your lordships have dealt with many cases of CBI. There are 2 concepts, my lord. First is PE and then RC. The FIR is equivalent to RC, registered
sir.
case. They say registered case RC.
By the CBI.
And P is preliminary inquiry. My lord, the preliminary inquiry was by the mandate of the Supreme Court in a case called Sirajuddin, a public servant, my lord, where they said that if the FIR that are direct, my lord, permitted to be registered day in and day out against public servants, their functioning will become impossible.
That's what is followed in Lalita Kumari prior to paragraph
So
120.
they have repeated Sirajuddin
Yes.
in 116 and 117.
Yes.
My lord, Sirajuddin judgment which gave this birth to the concept of PE, then, my lord, was also, it got an entry into the CBI manual. It became clause 9 and 12, my lord. So
That's why they register P and then RC.
10 hours. Now, but as my lord held in Lalita Kumari also, if the blatant, if the cases exercise can be seen even on the allegation on the information, even when there is a permissibility of PE, it is not a must. You are free to register. You are obliged to register a case, my lord, which is Lalita Kumari. So, my lord, I need not go into this because 17A is one, my lord, one area which is now pre-investigation only.
It's still
only-
little gray. not-
Exactly. So, my lord, if a circular goes that your complaint or your grievance redressal before the criminal competent court would be only with a permission under 17A, if that is to be appreciated and understood by the courts, then, my lord, whether I applied it on 4th of July or 31st of July is immaterial. Because as a citizen, what I need, investigation must be carried out. If something is required, must be done. The courts will decide whether it is required or not. As a citizen, I do not want to get with a stumbling block. That in my seeking my redressal through a process known to law, if there is a requirement of this approval, I must approach for approval and I must get approval. The court will decide whether approval is needed or not. That can't be read as one or something which is comic. Therefore, my lord, now in that background, kindly come to para 36 of, my lord, the judgment in Vishwanath Chaturvedi's case, where, my lord, kindly see, my lord, kindly come to page 66.
66.
Yes, my lord. Vishwanath Chaturvedi, kindly mark it, my lord, it is writ petition under Article 32.
Yes,
Kindly mark it, my lord, on the top, your lordship will get a writ petition.
yes, yes.
So, my lord, some allegations against the Chief Minister of Uttar Pradesh. A writ petition come directly to the Honorable Supreme Court under Article 32. The law is discussed and the direction is issued, including para 36. Before that, my lord, I just want to show two paragraphs. Para 33 at 79. Para 33, page 79.
Yes,
In our opinion,
yes.
In our opinion, the minuteness of the details furnished by all the parties and the income tax return and the assessment order, sale deed, etc., have to be carefully looked into and analyzed only by an independent agency. So, Your Lordship, I beseech you of Your Lordship's indulgence to keep in mind independent agency. And especially when the stand of everybody is unison, verbatim, that nothing has been made out. Carefully looked into and analyzed only by an independent agency with the assistance of chartered accountant and other credit engineers and values of the property. As stated by the petitioner, very valuable properties in the heart of the city have been purchased for lower consideration and less than the market value. Please make a note of the third figure, my lord, 55 crores. 3,24,000. 5,98,000 is the sale deed of 2004 of an agriculture land. And, my lord, 14 developed plots of land now given, my lord, which is worth not less than 55 crores. Otherwise, some statement made here and there on the media, my lord, more than 60 crores. So this 55 crores, which you have got, I ask this question, why should it not require an investigation? What did you pay? 6 lakhs in 2004 in a fraudulent transaction. Prohibited, not permissible, because there is no agricultural land available in the name of that original person. Nothing. And through this process, by relying on a similar case, which is not similar at all, you have enriched for yourself or your family member at least 55 crores. 55 crores. And what is your lordships are considering at the hub of the matter? Should it be investigated or not? I'm saying, my lord, supposing there was no 17 and nothing. The petition is before your lordships are under 226. The criminal jurisprudence is locus neutral. Your lordships could do it suo moto. Your lordships are having a proceeding where 226 is invoked for praying for a criminal investigation. My learned friend client obviously has come to stall it. Your lordships are fully equipped to pass an order here itself if your lordships are satisfied that 55 crore is a bounty, which is a clear express violation of the public trust by a public servant. Now please see, my lord, PMLA section 3. A beautiful 2 words, my lord, in PMLA, which I didn't see except for 120B. A process and activity. Kindly read the process here. Please see the process. Who has got benefited and how much? And at what cost? process activities. Now, my lord, please see 36 at page 80.
Mulayam Singh Yadav.
He is a senior politician.
Hmm.
Caesar's wife should be above suspicion. Kindly see. I'm not talking wife literally, my lord.
I know.
I don't mean to say anything, any disrespectful thing to anybody.
Yes.
He's a senior politician and holding a very high public post of chief minister in a very big state in India. And the allegation made by the petitioner against him have cast a cloud. I am, Lord, I am in submitting, my case is much better higher. It's not a cloud. It is ex officio demonstrable. Have cast a cloud on his integrity. Therefore, in his own interest, it is of utmost importance that the truth of these allegations is determined by competent forum. Such a course would subserve public interest and public morality, because the chief minister of a state should not function under cloud, and that it would be in the interest of respondent number 2 and the members of his family to have their honor vindicated by establishing that the allegations are not true. And my lord, supposing they are found to be true, then these three figures, 3,24,000, 5,98,000, 55 crores. I do not know where was I. Malad, kindly see, we have seen, Malad, people struggling for bona fide causes for release under 48. Some school buildings, some part has also fallen. Your lordship has so much of experience. Nobody, Malad, gives you an ear. Here something is developed. Acquisition completed. Plots sold. And Malad, de-acquisition. And then sale of agricultural land which is not in existence. Now kindly come to the next judgment.
Yes.
My lord, if your lordship may come to the judgment, my lord, starts at page 91. On public trust doctrine, my lord, in that Noida Enterprises Association case, my lord, of 2011, 6 SCC, page, my lord, 508. Para 38, my lord, is 107.
107.
My lord. Para 38.
Yes.
The state or the public authority which hold the property for the public or which has been assigned the duty of grant of lodging acts as a trustee. Please now keep all these observations in mind, these three figures, that they have to act as a trustee for that property, my lord, which is not less than 55 crores. Now, if it is a public largesse which has to go to a particular entity or a particular person of 55 crores, through this illegal and my lord, completely unknown process, unknown to law in such a circuitous method, and my lord, it becomes 55 crores when it comes into your hand. And therefore has to act fairly and reasonably. Every holder of public office by virtue of he acts on behalf of the state is ultimately accountable to the people in whom the sovereignty vests. As such, all powers so vested in him are meant to be exercised public good and promoting the public interest. Every holder of public office is a trustee. Then now para 39, 40, 41 and 42. Then, my lord, that observation, my lord, a respectful submission which I had made, that even for the framing of charges, the Supreme Court has said weaker than prima facie case, page 126, para 12, para 17. The judgment starts, my lord, at page 109, 126, para 17. Just permit me to read 2 lines. This is nominal post 197, post 90. The court is applying its mind, and the court has to frame charge where it is fully equipped with the material collected, all evidence is collected, is to be considered.
Yes.
Framing of a charge is an exercise of jurisdiction by the trial court in terms of section 228. unless the accused is discharged under 227. Under both these provisions, the court is required to consider the record of the case and documents submitted therewith, and after hearing the parties may either discharge, etc. It shall frame the charge. The kindly see, my lord, next to skip 2-3 lines. Kindly see, my lord, the sentence between just one line above placetum C, the
Yes.
satisfaction of the court.
No,
Lord,
that
I'm at page
that I've
1.
already seen and marked.
Sorry.
I was just saying, what was the offense in that case?
But this
It was
the-
abetment to suicide.
Yes, my lord, that lady had died. And then, my lord, this was the case where but this was the principle laid down. This is one judgment, my lord, which has been followed, but the words of this weaker than prima facie case, my lord, has appeared here.
Yes.
And the Supreme Court has laid down that as a test.
Yes.
138, my lord, your lordship may just make a note. Is a judgment, my lord, of the Telangana High Court, my lord, 138. Actually, it starts like this in the print from the High Court website,
Yes.
138. And your lordship may just mark bottom 138, bottom up to 140, up to 2 sentences on the top. This one paragraph which is unnumbered.
Yes.
I'm placing reliance on this, my lord, where this public trust doctrine has been applied by them.
YS Rajshekar Reddy.
Say in the Reddy's case.
Yes.
And then kindly come to my lord, page 291. In the same judgment, the last para.
Yes. Yes,
I just want to read this, my lord.
as discussed above.
Yes, my lord. As discussed above, your lord, I can save time, my lord. I can skip it. Your lordship may just make a note. This is the repeating and reiterating the
Okay.
same principle in this
So
case.
if you just print this in your note that you give.
I will add it, but one or two things, my lord, which I want to show.
Yes,
I
yes,
want to
that's
show
all right.
4 or 5 paragraphs from my
Yes.
lord, in the development.
Yes,
Page 368, my lord. 368, Union of India versus Shiv Kumar Bhargav, 1995, 2 SCC, page 427, para 4,
yes,
369.
yes,
Just permit me to read it, my lord.
yes,
The policy of the government, my lord, this was policy for land, my lord, alternate land development, etc. Land, a lot, developed land to be given. Person whose land was, the policy of the government indicates that the person whose land was acquired means the owner as on the date notification was notified for acquisition, and he alone will be entitled to allotment of alternative site. Now, my lord, the argument which your lordship would be required to deal with, whether the denotification is to be accepted at all or not before investigation. Because that may bring a change. But, my lord, when I say that the compensation determined, compensation deposited, and the land in the revenue entry is in possession, got developed and sold, then all these principles apply with full force. And that would be a subject matter of investigation, because as I said, my lord, I am not defending a 48 release. I am only showing a expressly impossibility of that. And therefore, there is apparent that things have been engineered and created. Page 378. 378, my lord, at 382, para 5. This is the case, my lord, celebrated judgment followed various my lord, para 5. And the last, my lord, just above placetum D, the only right which he has is only for that monetary compensation. That's all. Nothing else. And this has been followed, my lord, repeatedly by Delhi High Court, my lord, which is at 384, at 398, para 9 and 10. Now, my lord, kindly come to thereafter 416. Here, my lord, the release was being made so that to enable to take away the land, my lord, for the builders. My lord, the Supreme Court considered this matter came from, my lord, Gurgaon, Haryana, where, my lord, the contiguous land, etc. The government was used to make larger chunks of land available to the builders because of the principle of contiguity. And my lord, that where the Supreme Court heavily came down on such an exercise. And the relevant part is at 440. Para 24, 25, 30 and 31. I'll put it in my note. Just your lordship may just make a note.
Yes.
And kindly see, my lord, para 31. 31. Power to release land from acquisition has to be exercised consistent with the doctrine of public trust. Here it has not taken place, it's only generated now. Because they are mutually they can't coexist. That is the development continuing after the award and the money, compensation, development continue, development develop plots hold. They can't coexist. Now, my lord, 444 is the judgment in Shiv Kumar's case, my lord. Your lordship may just make a note from para 7 onward at 451. Para 7, my lord, your lordship may just permit me to read one line.
Yes.
7 at page 451. We advert to the legal position concerning the purchase made on 5/7/2001 made after notification under section 4 had been issued under the Acquisition Act. Law is well settled in this regard by a catena of decisions of this court that an incumbent who has purchased the land under has no right, and kindly see the quoted portion from Jal Nigam in the next paragraph.
Yes.
That apart, since Messrs. So and so property, the respondent had purchased the land under notification 4/1 was published, the sale is void against the state. The quoted portion, my lord, para 7.1, para 3. It's void because the land has stood vested in the state. It's void. Kindly see para 8 at 455. It has been laid down purchasers on any ground whatsoever cannot question proceeding for taking possession. A purchaser under section 4 notice does not acquire any right in the land as the sale is ab initio void and has no right to claim land under the land policy. Kindly come to my lord 4 paragraph, which I indeed, my lord, with your lordship permission, wish to read 465 in road development on 2 points, as I said, my lord, on payment of compensation and taking over the possession. 578. Para 116. My lord, just permit me to read 4-5 paragraphs here, my lord.
Yes.
It would be helpful for me to explain, my lord, and my lord, submit for your lordship consideration the points which I am raising. My lord, your lordship has seen that just one day before the honorable governor noted the letter is written by that my lord, the compensation is not paid one day before. Now, in that context, kindly see 116. It is apparent from a plain reading of section 16 that the land vests in the government absolutely when possession is taken after the award is passed. And I have, Lord, made 2 submissions for your lordship kind consideration for a case made out prima facie for investigation is that, my lord, it already stood entered into the revenue record as the government as the owner. And, my lord, the compensation stood determined as 3,24,000 and, my lord, wherever to be deposited or given. Clearly, my lord, your lordship has skipped 4 lines, and then, my lord, 2 lines above at last 4 lines. Once an award is made and possession is taken by virtue of section 16, land vests absolutely in the state, free from all encumbrances. Vesting of land is automatic on the happening of the 2 existing exigencies of the passing award and taking possession as provided in section 16. One possession is taken under section 16. The owner of the land loses title to it and the government becomes the absolute owner. Payment of compensation under the act is provided under section 31, which is after passing of the award under 11. Please come to 119. Section 34 deals with a situation where any of the obligation under section 31 is not fulfilled. When the amount of compensation is not paid or deposited on after taking possession of the land, the collector shall pay the amount awarded with interest thereon. Because, my lord, your lordship may just keep this in mind, 31, 34 of the old act, that even if it is not deposited, What you can get is 9% interest. Please read this paragraph with me, my lord. The collector shall pay the amount awarded with interest at the rate of 9% from the time of so taking possession until it shall have been so paid or deposited, and after 1 year from the date on which possession is taken, interest payable shall be 15%. The scheme of the 1894 Act clearly makes it out that when the award is passed under section 11, and my lord, our case is old act, this is applicable. Thereafter, possession is taken as provided under 16 land vests in the state government under section 12(2) notice of the award. Taking possession is not, please mark it, my lord. Taking possession is not dependent upon payment. Payment has to be tendered under section 31 unless the collector is prevented from making payment as provided and so and so. In case of failure under 31 or 31(3), the collector is not precluded from making payment, but it carries interest at the rate of 9% for the first year and thereafter at the rate of 15%. Thus, once land has been vested in the state, section 16, case of failure to pay the compensation under 31 to deposit under 31(2) has to be paid along with interest. And then, my lord, 4 lines thereafter, in a case where possession has been taken, etc., under 16 or 17, that emergency awards, etc. Then kindly come to para 128. 128.
Yes.
Section 48 is quoted, my lord. Constitution bench also deals with section 48.
Yes.
48 is reproduced. Kindly come to last 2 lines of 40, just above 129. In case possession has been taken, there cannot be any withdrawal from the land acquisition proceeding under. So, my lord, the question which is required for investigation, obviously the other side would say we have a notification of some 30th of May 1998 of deacquisition. But before that, my lord, in 98, the land revenue recorded the government is already the owner and the land is already a part of the development scheme developed and sold. So this would require investigation. And, my lord, if in the investigation, if my submission is found to be correct, my lord, that it is engineered and created later on, then all these principles, my lord, will cover. And they will apply with full force. Therefore, my lord, as of today, there would not be any, my lord, blockade or prohibition or impediment, not that there should be not an investigation by an independent agency to do this. Not those who are in, not by them, those who are unison with the petitioner. Now, my lord, kindly see 1 or 2 more paragraph, 129.4, which your lordship may just make a note, I am not reading. Page 659. With regard to possession, page 659, my lord, the title is Mode of Taking Possession, my lord, para 246 to 47.
Yes.
And, my lord, supposing in 247, a particular, my lord, entry on the file or some kind of a parchi to be drawn up for, my lord, the paper possession also. Who will find out where is that slip before it entered into the government revenue records and the possession is taken and it is given to the pool of the total 268 acres, my lord, for this third phase, which stood developed. It will only come out through that investigation. Because without this, my lord, it could not have been a part of the award and, my lord, the part of the development and, my lord, the entry in the revenue records in the name of the government. It was not possible. Those are the things, my lord, which have taken contemporaneously in accordance with law. Thereafter, my lord, the reversal has sought to be created. Page para 261, my lord, thereafter 246, 247. Then, my lord, para 261. Please see 261, para first 4 lines, my lord. I am not reading it. Just see, my lord, what would the requirement. Even going to the spot is enough. And here,
Symbolical.
yes,
Even symbolic possession.
absolutely. And, my lord, even going is enough. And this is confirmed, my lord. Earlier there was a doubt whether, because, my lord, the new act now says physical possession. That also, my lord, the court has considered. Now, my lord, please mark that page, my lord, 669, para 266. And my lord, 366, which is the last conclusive portion. And my lord, few paragraphs which I want to read only, my lord, only to add what the learned solicitor and even my friend on the other side have read in Subramanian Swamy. My lord, the compilation by the petitioner which is given, there is this page 271. Page 271.
Additional complaint, list of judgments, whatever petitioner. Volume 1. 271.
Yes, add 283, my lord. Para 2 and para 3. This is a private complainant applying for sanction.
Yes.
Para 1 and, my lord, para 2 and 3, your lordship may just make a note because my learned solicitor general has read the other portion. Kindly
Yes.
just, my lord, for properly appreciating it, 2 and 3 may be relevant. It's a private complainant who goes and seeks a sanction.
Yes.
Para 10, my lord. And then he is compelled to file a writ petition in the High Court,
Yes.
which is para 10. And then kindly come to para 19.
Yes.
And what your lordships observed, my lord, it is only a prohibition against the police to proceed. It does not create a locus standi for somebody or prohibits a locus standi for someone else.
No,
And my
that
lord, your lordship may kindly see. My lord, if your lordship may kindly see 17A and
A.
19, your lordship must be remembering, only submission is this. If I ask a question to myself that who will not proceed is given, against whom you will not proceed is also given. Why is this that it is silent, that who will seek it?
So that's immaterial. That's not.
No, my lord, I'm saying that that is the incorporation of the doctrine of locus standi neutral in the criminal jurisprudence. It is the manifest.
If it were to be that an aggrieved person only can seek,
Exactly.
it
my
would
lord.
have been there. It is not that.
So therefore, Subramanian Swamy explains, my lord, that since the crime is against the society, everybody has got the locus standi.
No, that's why it is.
And therefore, if your lordship may just see one paragraph here,
Yes.
para 30. Just see para 30, my lord, only for a moment at page 292.
Of volume 1, right?
Of the judgment compilation of my friend on the petitioner, my lord. Your lordship was seeing this judgment of Subramanian Swamy there. Volume 1. And my lord, the printed page, if the page is not handwritten, these are the pages, my lord, which have come in a small font in the printing itself. This was given on the first day, my lord, Subramanian Swamy's case. The learned solicitor had also
No,
read
that
some
is
more.
of which one, sir? You mean this?
यहीं से पढ़ देते हैं 28 से
Other good.
20 and 30, 44 हैं
They are not even. Give that. Other third.
page
Where is this?
para 28 para 30 and then 44 para 28 your lord-
Page, sir.
page my lord it is कहाँ है page यार मैं भी नहीं देख 292
292. Yes, sir.
on the top my lord it is
Yes.
getting smudged it's getting mixed
Yes,
up
yes, yes.
now kindly come to 28 para 28 page number is 292
Yes.
the sentence start there is no provision.
There is no provision.
Yes, there is no provision either in the 88 Act or Code of Criminal Procedure which bar the citizen from filing a complaint for prosecution of public alleged to have committed offense. Therefore, the argument of the learned attorney general that the complainant cannot file a complaint for prosecuting respondent for merits rejection, then Antule, and then para 30. Kindly see para 30. While dealing with the issue relating to maintainability of private complaint, the Antule's portion is well recognized principle of criminal jurisprudence that anyone can set or put the criminal law into
Yes,
motion except where so and so.
That's
And my
settled.
lord, para 44.
Hmm.
Para 44.
Yes.
and para 44, and then kindly see 44, my lord, the middle of the line, by the third line, my lord, whether the facts placed before which in a given case may include the material collected by the complainant or the investigating agency.
Yes.
Kindly see that third line, my lord. Let me read it. We may have a grant of refusal sanction is not a quasi judicial function, and person for whose the prosecution sanction is sought is not required to be heard by the competent authority before it takes a decision the matter. What is required to be seen by the competent authority is whether the facts placed before it, which in a given case may include the material collected by the complainant or the investigating agency prima facie disclosing commission of an. So source can be any, person may be any. Then, my lord, your lordship may kindly make a note, para 68 and 75. Para 68,
Yes.
there's today corruption, etc. 75. Now kindly see 75. Just permit me to read these few lines.
Yes.
Therefore, in every case,
Yes.
and this is also one of the, my lord, concurring opinion, in every case when an application is made to an appropriate authority for grant of prosecution connection with an offense under the PC Act, so my lord, please see appropriate authority. So whichever authority, whatever is needed, I as a citizen have applied.
Hmm.
So what is to be done now? For grant of prosecution in connection with the offence, it is the bounden duty of such authority to apply its mind urgently in the situation and decide the issue without being influenced by any extraneous consideration. In doing so, the authority must take a conscious effort to ensure the rule of law and cause of justice is advanced. In considering the question of granting or refusing such sanction, the authority is answerable to law and law alone. Therefore, the requirement to take the decision with a reasonable dispatch is the essence. In such a situation, delay in granting censure proposal thwarts a very valid social purpose, namely the purpose of speedy trial with the requirement of bringing the culprit to book. Therefore, in this case, the right of the sanctioning authority while either sanctioning or refusing to grant is coupled with a duty. The sanctioning authority must bear in mind, and up to 77 that, my lord, they are saying that there should not be any delay in that regard. Therefore, my lord, if your lordship may kindly see at the cost of repetition, what I am submitting and making my humble submission, my lord, for this respondent is that sufficient objective material with their admission now through the form of their notes and document has come on record. And therefore, my lord, an investigation is needed. Whatever is required to me, either to file a complaint or to apply to the governor under 17A, whatever is applicable, I have done so, and my lord, in this jurisdiction under 226, notwithstanding who has invoked it. If your lordships are satisfied, my lord, that the case is made out, that the investigation should not be impeded, my lord, your lordship would consider that, my lord, and my lord decide the matter. That's my respectful submission, my lord, only with the liberty that I'll hand over my note with this,
Yes.
whatever I've read in, my lord, by today evening or by Monday.
Yes.
And Mr.
So-
Raghavan, my lord, has requested me to, my lord, we will supplement it on Monday something. Grateful, my lord.
I have about half an hour.
Continue. 2:30. ಆಯ್ತು ಆಯ್ತು 2:30 2:30. You have concluded, Maninder Singh, sir?
Concluded.
Yes.
2:30.
Sir is also concluded? Yes. We'll continue at 2:30.
I may leave a little early today,
Yes,
but
sir.
I'll be there while it's virtual or physical when Mr. Raghavan is
problem, sir.
arguing. Then I'll work out the dates with the lordships.
So you want to reply to the submissions already
I
made,
need
you
to
can.
put all this together now. There's
Yes.
a massive 61 page plus all these other things. I'll want to in fact take
That's
some
better.
time to put things together into one single
Yes, sir.
document. So
Yes.
in any case, Mr. Raghavan is arguing, so he can.
Yes, sir, yes.
So I was just. saying
Anyway,
I
my
may
lord,
be
just
excused- I
clarification.
may be excused for the last half an hour or one.
No problem.
Considering, my lord, the scope of the present petition, whatever my learned friend Mr. Singh argued, is obviously only for the purpose of showing that it's not just a haphazard way of prosecuting someone. There is a material. So it's the scope of the petition would not include
While
defense, etc. my lord.
While your lordship is rising, this is not the right time, but I'm very, very touched by this slight, very mild caveat. I didn't interrupt Mr. Singh once, but it's going to be my argument that in my sanction, my learned friend has argued anything but sanction. He has argued merits.
No,
Every
that's what-
case he has cited
The
is a
reply-
case. He goes to the extent of saying in my sanction petition, your lordships can become a 226 court to grant him sanction. That's his argument.
No.
Not
Just
one
to
single
prima facie
sanction
show
case
that
is
there is a
cited.
Argument is that there is abundant material
No, he
Not
said
that you
anybody
can give
come,
your
therefore
defense
sanction
here
can be
and
granted.
get a acquittal.
Anyway, well, we'll
You
deal with
can't
that.
argue on defense, that's all.
Because locus neutral, therefore anybody can come. Governor must grant sanction. Because anti-corruption, public trust doctrine, we are arguing a sanction under 17A or 19 or whatever it
Eh.
is. Not a word about it. But anyway, well, that's why I need some time to analyze these cases, tell you what these cases are about. They are chalk and cheese, because we're talking of North Pole and South Pole of the subject. So I'm concerned.
Yes. We'll continue at 2:30.
Please.
Yes, thank you, sir.